she did some of those supervised visits. And so she had interaction with Maya and Jack and observed behavior and things. And I don't recall offhand Nicola check. Would have to check on that.
Just so everyone's aware, tomorrow I do have a meeting at noon, so we'll have to make sure our lunch break includes the noon hour.
Okay.
Let's move on to Sally Smith. I did receive the transcript plus the page and a half that the plaintiff wishes to use. What was the counter designation that the defense was seeking?
Judge, I don't have the transcript, actually. Judge, I think the issue was that
I remember what it was.
I don't have the transcript.
Yeah, we'll pull it up, but the problem with the question, because I believe what they wanted to put in was that Sally Smith accessed the hospital record, correct? And the previous question was about the first call to DCF that I thought was motioned and eliminated out. Am I wrong about that?
Well, right now I'm trying to figure out what the rule of completeness designation is. So
What we would have to put in for context is the questions that preceded it about a page before then, but I thought that would go into inadmissible testimony.
I need to know the
What
page and line
Yeah,
numbers.
I got it. Sorry, Your Honor. Let me pull it up.
Do we have that to pull up, the page and line, or the pages we're talking about for Sally Smith?
What, do you have, Your Honor, are you looking at the transcript?
I am.
Do you mind, I apologize for inquiring, but can you tell us which date the transcript?
This is the February 28th, 2020. It says the full corrected.
And what page number are they trying to?
Well, the designation started at page 451, line 24 through 453, line 1.
Okay, we'll be right there, Your Honor.
And while they're looking for that, I'm going to go to the plaintiffs. And where are we on the first DCF call?
Where are we on the first DCF call?
How are we handling that first DCF call, if at all?
Well, I thought the fact of the calls was not excluded. I mean, the content of the calls, the jury's aware there's a call or reports, and the court's made a determination those are in good faith. But the fact of the calls is not excluded.
And the question then becomes, should the text of the calls be put in as well? In other words, the results. We obviously think it should, but
Yeah, I see this again, Your Honor.
Okay, you have it.
Right, I apologize. I just don't have the designation they're trying to put in, but I believe you said the designation they want to put in is about accessing the record, correct?
It's
Starting on 452, line 8.
451, line 24.
They want to put in 451, line 24.
What I was told was 451, line 24 through 453, line 1.
Again, what was your reason? I was asked to consult. So I can't ask to connect to the call. Keep going down. They want what? They want 453, go. Ending at just randomly, Judge? On
453, line 1.
Yeah.
Yeah, this is. I want this. If they're gonna do it.
And we would want through 453, line 23. I think up through 23.
I think if they're gonna read that, we would ask that to continue to page 453, line 23.
Plaintiff, can you tell me why we need this?
Your Honor, this is further confirmation of what we argue is agency of Dr. Sally Smith and the confirmation of the inappropriateness of her accessing Maya's medical record outside of any state investigation. And she confirms here that she consulted as part of her active staff privileges. So it's material relevant to the apparent agency allegations.
If you need a response, Your Honor, I can.
Yes.
She, as a staff physician, she has access to the records, but the reason she was accessing the records is if you read on, which is why we wanted the counter designation, but she was doing so as part of her official state function as an investigator, and in order to draft and prepare her report as part of the medical evaluation for the child protection team, as it says on page 453 at line 23. So that would be the context of this. Which is why we would need the entire context of this. Sally Smith, I understand, is going to come live and testify, so a lot of this can be covered with her. I'm afraid this is taken out of context, but if it's going to be put in, it would have to be put in. Yeah, in terms of whether this would establish a parent agency, that only goes to what Johns Hopkins All Children's Hospital would have held out to the Kowalskis. Her accessing records outside of the knowledge of the Kowalskis has no bearing on the apparent agency claim, which is what I think they're trying to perfect at this point. Thank you, Your Honor.
Well, here's my view, because it looks like the plaintiffs are trying to get the accessing on the 8th and not subsequent, so just on the 8th. Am I correct on that?
Correct. We recognize her status changed as of the 9th.
And the question on page 453, the line 15, which is starting at line 15, which is part of the completeness, talks about after the status change. So I'm not sure that's completeness.
Well, Judge, but their stated purpose for putting it in is for a parent agency. Parent agency has to do with what the Kowalskis knew or what was represented to them. Whether or not she accessed the records seems not relevant to that claim. And if it's not relevant to that claim, what's it relevant for?
What if we start at 452 line 4 as you sit here today and have that question relative to the 8th? And then, for the rest of the plaintiff's designation, so that's through 453, line 1. If the defense wants the questions about what did you learn on the 8th,
I don't think we want the rest.
well, it looks like the question ultimately was converted to something for accessing after the 8th.
Right, yeah, that's correct, Judge.
Yeah.
So
So-
we would be fine. I mean, we understand the court's ruling about the subsequent
So
testimony.
I will allow the Sally Smith deposition beginning at page 452, line 4, as you sit here today, through line 1 on 453. Now, are you able to cut it right now, or are we just going to read that?
I can, I already have the clip created and I could start it precisely where it says, so I don't have to go through the editing and re-rendering the video, if that's okay with.
That's fine with me.
Does that mean that they're playing it? I'm sorry, I didn't quite understand.
Yes, they're going to play it, but I guess they already had it,
Okay,
the snippet, a larger snippet, and they're just going to start it where I said they could. Are we doing that first, or are we doing Newberger first?
Your Honor, I suggest we read it because I'm afraid that the subtitles, if you will show some of the testimony just excluded.
Good point, so
There's no subtitles on this,
Oh.
this clip.
I spoke out of turn. There's no subtitles.
I just.
are
no
we confident
subtitles?
there's no subtitles?
1,000%, Your Honor.
Are there any exhibits shown?
No, no, I'm going to test it here.
Okay. So why don't we read Newberger first,
Yes.
and then that'll give you a chance to do what you need to do.
Thank you.
Okay. And just as a reminder, I know I said this the other day, but just so the transcript is doubly clear, I'm going to time shift when we're going to do the DV motions until 3 o'clock today, such that when the plaintiff rests, I'm going to turn to the defense and ask them to call the first witness. And we're not going to do DV motions immediately. We're going to do it at 3 o'clock today. So that's based on my view of how to use time with the jury.
Yes, Sean.
Your Honor, I requested from the clerks a list of those documents that are exhibits that had been marked for identification but not moved into evidence. And I confess that I didn't ask it until after lunch, and it will take them a while to come up with that list. So we would like to rest, but counsel was kind enough to agree that we could rest subject to that list.
right, that's my I'm sorry, that's my understanding is that they just need to confirm which ones have been marked for identification. They're not looking to put in additional evidence.
Well,
Correct.
The whole purpose of it is that if there was something that was marked for identification at the beginning of the trial and through the testimony and evidence, or I put it in under 90.105 and simply forgot to move it in. So I
Oh,
can't
no,
agree.
I'm sorry. I thought he meant he wanted to make sure he had everything marked for identification. I'm not clear. I'm not clear on what's being asked.
Well, because I don't want the jury to just sit around
Right.
while the clerk is waiting.
Right.
Perhaps we'll see how long it takes the clerk to do that, and then if, even though Mr. Anderson technically rests, if we can deal with it this afternoon, if there's anything.
I doubt there is, Judge. We're pretty good about getting
Yeah,
it in, but
that's
it's the
fine.
safest thing to do. Good lawyering.
Okay.
Okay. Anything else?
Just a very minor time issue, Judge. We have our first deposition. So we were uncertain about time, so we didn't schedule that live this afternoon. Our first deposition is an hour and like 5 minutes. We'll probably be starting at around 2 o'clock, like we're shortly before 2. Then our second deposition would be about 40 minutes, which is just long enough to be too long. So I want to let Your Honor know that. So we might be, it might be like 2:30 or 2:45.
It'd be 3:30 or 3:45, and that to me is a question for Mr. Altenburn and Mr. Elliott, because Mr. Altenburn was the one
Right.
wanting to dial it back from 4 o'clock to 3 o'clock.
Our suggestion is we just play the one deposition, which is an hour long, and assuming we're at 3 o'clock at that point, that would be all the evidence today.
It might be like, again, it might be like 2:30, 2:45.
Yeah, we're already at,
You're already at 1:30.
It'll be 3.
Okay.
yeah, we're already at.
Mr. Elliott, was there anything you wanted to say, or?
I heard my name, so I stood up. No, that's, we haven't talked about how much time, and I'm fine starting at 3:34, whenever.
Mr. Altenburn made an impassioned plea for 3 o'clock as opposed to 4 o'clock.
I think you'll be fine, Judge.
Okay.
Whenever.
so we ready to bring the jury in?
Yes, Your Honor.
And you know who's reading?
I'm just
Newberger?
gonna read the question and answers, Judge. It's 5 questions. You don't like that?
Well, for help with the jury, I think you need to have
That's fine.
a reader,
Okay.
a questioner and a reader.
I only have, we'll just stand up there and do it. But I don't have 2 copies.
I'll bring my computer.
Okay, let's bring in the jury.
It's the last deposition. It's the March 24th.
Designations in Newberger.
They were actually their designations, but they didn't. It can count. It can count for time.
Okay, welcome everybody. Please be seated. Jury, I want to confirm while you were away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that correct? Correct. And that you have not seen any media coverage on this case over lunch. Is that correct? And you haven't been approached by anyone over lunch. Is that correct? Correct. Now, our next witness is Dr. Newberger. And there's only a few questions by deposition. And I think Ms. Crowells and Mr. Shapiro are going to.
So this is,
I guess it's playing the younger Dr. Newberger.
yes.
All right.
So this is just some testimony that was inadvertently left out when Dr. Newberger's deposition was played the other day. It's the deposition from March 24th, 2022. Okay? Page 41, line 3. When was the last time that Maya Kowalski received intravenous ketamine?
Oh, it's been some time. I mean, she's been doing well without it, but I don't recall.
When was the last time that Maya Kowalski had oral ketamine, to the best of your knowledge?
I don't know.
Do you know what Maya Kowalski's current medications are?
No.
Do you know how Maya Kowalski's doing in school?
It's my understanding she's doing extremely well. She's a very fine student.
Thank you. That would conclude.
Thank you. Now, the next witness is plaintiffs. It's Dr. Sally Smith. Is that correct?
Yes.
Okay. And this is also a very short deposition clip, but I think we're playing the actual deposition in this. It's only a couple of moments, so I'm not going to worry about the lights.
But that was half the fun.
Actually, wait a second.
No, it's.
I heard it. See, over the weekend, I lost how to do this. Are we ready, Mr. Reyes?
Yes, Your Honor, just a moment.
Your Honor, does he have, oh, there it is. All right, it's on the screen.
You sit here today and your knowledge based on what you know today, was there an open investigation on the 8th?
I guess there was not.
So again, what was your reason for accessing Maya's medical records?
I was asked to consult on the case as an active staff member at All Children's Hospital.
Who gave you access at Johns Hopkins to do that?
I have remote access to the medical records of children I'm consulted about as part of my active staff privileges.
Could you access anyone's medical record within Johns Hopkins via that remote access?
I guess technically I could, but I wouldn't do that just randomly.
And that completes the playing. Mr. Anderson, do you have any more witnesses?
No, Your Honor.
And at this time, is the plaintiff resting this case?
Subject to a list to be marked, the plaintiff rests.
Defense, please call your first witness.
The defense calls Dr. James Lewis by deposition.
Taken on August 12th, 2019.
Now, members of the jury, is that tray light a little bit too bright? Do you want me to dim it or attempt to dim it? Dim it a little bit. Okay. How's that? It's coming back to me.
Here begins the videotape deposition of Dr. Here begins the videotape deposition of Dr. James E. Lewis.
Would you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give in this cause is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning, Dr. Lewis.
Good morning.
Today you're here for video deposition, Ducis Tecum, and this morning we received 20 pages from your attorneys. Do these pages that were sent this morning, I have a copy here for you, we'll enter as Exhibit 1. Does that represent the entirety of your file related to Maya and Beata Kowalski?
Can I take a second to look?
Absolutely.
Any pages?
I think it's 20.
It looks like it's everything except my report. I don't see my report in here.
Right, I didn't see a report in there either, but I do have a copy of your report.
Okay, so it's everything but my report.
Given that I've looked at these 20 pages, your file doesn't include any medical records of Maya Kowalski,
No,
nor of Beata Kowalski.
no,
Does your file contain any psychological or psychiatric records for Maya Kowalski?
no,
Same question for Beata Kowalski.
no,
Did you have any records from Eagle Wings?
I've never heard of it.
It's a counseling center. I'll take that as a no.
No,
Any records from a counselor named Rebecca Johnson?
no,
Did you review any of the Johns Hopkins All Children's Hospital admissions notes, documents, medical records?
I didn't review them. The only thing that I saw was the day that I went to see Maya. I asked the nurse who signed me into the unit what medication she was using that day. I saw her in the early afternoon. And I wanted to see if there were any medications she was taking that could affect the test performance. And she had her file, the chart open, and said the only medicine that she was being given at the time was Tramadol, but she had not had it on the day of testing. So I didn't review the file, but she read that out to me.
Okay. And that would have been on October 18th, 2016.
That's right.
So other than the nurse's records reflecting the medications that were or were not taken that morning, you did not review any Johns Hopkins medical records?
No.
Our Schedule A also requested notes, summaries, documents, emails, correspondence, and writings reflecting telephone calls with Sally Smith.
Never spoke to Dr. Smith about this case.
Never spoke to Dr. Smith about the case. Did you ever text Dr. Smith about the case?
No.
Did you ever email Dr. Smith about the case?
No. All my emails were included in that file that you have.
What's labeled Dr. J. Lewis' response, Spina Ducis Tecum 001, appears to be the lone email ahead of your visit. Is that correct?
The lone email before the visit.
Is that correct?
That's correct.
And this represents the only communication?
The only what?
The only communication about Maya Kowalski before you visited her at the hospital?
Correct. Well, not exactly. No, that's the only communication. But there were the attachments that you have in here. They were sent as attachments to that email.
Right. So, looking at the first sentence of that email, I think you have it in front of you. Here is some information on the child you'll be seeing at All Children's Hospital tomorrow.
Right.
As I read that sentence, it seems to suggest there was some pretext to this, that you had had a discussion with someone about visiting the child. Were there any previous conversations?
I was on vacation the week before, and Diana Dove had left a voicemail for me to call her to see if I could see a child that following Tuesday. And so I said, just send the information to my email and I'll look at my schedule when I get back. When I got back on Sunday evening, I saw that I had central neurology cases on Tuesday morning, but I'd be finished at about 12:30 or 1. And so when she sent the information, I called and left a message with her, yes, I'll be going to see Maya.
Okay, so if I understood your answer, there was a voicemail left at your office while you were on vacation, is that correct? There was a voicemail left at your office while you were on vacation?
Right,
And you returned a call to Ms. Dove?
right.
Okay. And during that call, you discussed what?
No, I left a message,
A message from Ms. Dove.
right, saying that I would in fact be able to see Maya on the date that they requested.
Okay. And that represents your sole correspondence prior to this email?
Correct.
Did you take any notes during Maya's exam?
I had a few handwritten notes, but I dictated the report within 10 minutes of when I left the hospital. All the notes that I wrote in the report, more than those notes are in the report. So from page 6 to six, 7, and most of 8, where I'm going over my interview with Maya, which is, I don't know, hundreds of words. I had taken some handwritten notes to affect my memory, but I didn't really need the notes because I dictated the report so quickly after I left the hospital at about 4:30. My home is 10 minutes from there. I went into my office and dictated her report 10 minutes after I left her.
Did you retain those handwritten notes?
I did until Hurricane Irma.
And then?
Well, I moved to Florida in full-time in 2012. I had never been in a Florida hurricane. I have a garage studio, had a 2-drawer lateral file cabinet. We were in the area of St. Pete that was hard hit by the storm. We had huge laurel oak branches, not branches, big limbs, hit our house, and the storm drains were backed up, and the water came into my garage and ruined all of the bottom cabinet full of records, which is all of my Florida records.
Fair to say those notes were destroyed?
They couldn't even be, we have a requirement in our field to take stuff to a medical place that will shred. They were so wet they couldn't even be shredded.
Okay.
And I didn't have flood insurance, not thinking that I needed it, so it wouldn't have mattered. They wouldn't have paid me for pieces of paper anyway.
You mentioned you dictated the report, is that correct?
Yes, sir.
Is there a copy of that recording?
This is it.
Okay. You administered a number of tests to Maya Kowalski during your evaluation, is that correct?
Yes.
Did any of those tests, written tests, answer forms, did any of those survive?
No, and all of the tests that I gave Maya, the scores from every single test I gave her are listed in the report.
Are those tests administered on computer or on paper?
On paper. Well, they're mostly verbal, and some of them are blocks and puzzles that the child manipulates. Then I hand score it, and then I dictate my report from the hand scoring that I did. I didn't do a computer scoring. There were no tests that she took that were done on a computer. It was all either me writing down her answers and scoring it, or in a few cases she had to use a pencil to write certain things down as part of the tests.
So the first 16 pages represent the entirety of what you knew about the case prior to walking into Johns Hopkins Hospital.
That's right.
Okay. And I just want to, for the record, I think when you said page 21, you meant what's marked as SDT 020. Is that correct?
Oh, that's right. Yeah, sorry.
Okay. All right. Prior to going to the hospital on that morning in 2016, how many evaluations had you conducted at Johns Hopkins All Children's Hospital?
Maybe 5.
5, okay. And were the bulk of those in 2016?
Let's see, no. I've done 5 in my life there, from 2013 till now.
Okay.
Maybe she was maybe my 3rd one.
Okay. Do you hold staff privileges at Johns Hopkins Health Children's Hospital?
Do not.
Did you work with risk management ahead of going to Johns Hopkins Health Children's Hospital to obtain access?
Did not.
Did Dr. Deese, Paula Deese, contact you about obtaining staff privileges prior to arriving at the hospital?
I wasn't asked to obtain staff privileges.
Did anyone mention staff privileges to you ahead of
No.
your arrival? That email, the second paragraph, also mentions some information that was relayed by Dr. Smith. That's Dr. Sally Smith, is that correct?
That's right.
And the discussion is about some ketamine treatments. Other than what's contained in the paragraph there, did you know anything about Maya's ketamine treatments ahead of arriving in the hospital?
I believe it's mentioned in some of these other pages.
Okay. The DCF reports as well.
The Child Protection Team reports.
Okay.
The Child Protection Team is not DCF.
Please explain the distinction.
The Department of Children and Families is a separate cabinet office, and they subcontract to community-based care centers. The Child Protection Teams are in Florida organized under the Florida Department of Health, which is a separate cabinet office.
Okay. And so the lead agency involved here was who?
Well, at the time that I got involved, it was it gets complicated. The way that 6 out of 67 counties in Florida do it, the Child Protection Team are under the Health Department, and the Child Protection Investigators are under DCF contracting through the local Sheriff's Department. In all of the other 61 counties, the CPIs, the Child Protection Investigators, are directly under DCF and not through a local Sheriff's Department. So in this case, it was the 2 agencies, the CPI office, which is contracted through the Pinellas County Sheriff's Department, and that's CPI, and then CPT, which is the Child Protection Team, is the Department of Health.
So to rephrase, any advanced knowledge you had of ketamine treatments came from this relayed information from Dr. Sally Smith and the Child Protection Team intake reports, of which there are 2 here.
Well, some of those are CPI reports, Child Protection Investigators. I know it gets complicated, but some of these they refer to the CPI.
The second page is a letter from October 17th, the day prior to your visit. The header is Child Protection Team. Do you know who authored that letter?
It was Diana Dove.
That was a letter written by Diana Dove.
Right.
Okay. So there are 2 intake reports here, October 9th, 2016, and a subsequent report on October 10th, 2016.
Can you tell me what page you're on?
Page 3
Okay.
begins the October 9th report, and page 6 begins the October 10th report.
Right.
Were you provided a copy of the October 7th report?
I have here everything that I reviewed.
Were you aware there was an October 7th report?
I was only aware of what's in this packet that was given to me.
Did Diana Dove mention in her voicemail that the October 7th report had been screened out?
No, never heard of that until you just mentioned it.
That's the first you've heard of an October 7th report.
Right.
Did anyone make you aware that they had contacted Maya's treating physicians?
No.
Were you aware that Dr. Sally Smith had contacted Dr. Anthony Kirkpatrick?
I would only be aware of what's in these records here.
Okay. And that's because you didn't have a conversation with Dr. Smith, correct?
Right.
So she would have had no way to communicate that information to you outside of this letter or what Diana Dove relayed. Is that correct?
Or somebody would have had to email it to me.
And did that happen?
No, you have everything.
Okay. The second paragraph on page 2, to direct our attention back,
Okay.
mentions Munchausen syndrome by proxy.
Okay.
Did that affect your evaluation heading into the hospital?
I think you mean the, wait a minute. It doesn't matter to me, but I think it's like, you're talking about the fourth paragraph?
I'll read from the, so it says, Dear Dr. Lewis, then there's a first paragraph, begins with thank you.
Okay.
The second paragraph, 4 lines down, first words are Munchausen syndrome by proxy.
Right.
Concerns for Munchausen syndrome by proxy.
Right, and it's also in the fourth paragraph.
Sure, it appears several times in this report. correct?
Yes.
Do you know who had the concerns for Munchausen syndrome by proxy?
Whatever it says in that letter.
It just vaguely says concerns, so I'm wondering if you have any independent knowledge of whose concerns.
No.
And Munchausen syndrome by proxy, is that a DSM-5 diagnosis?
It used to be in the DSM-5. It's still used interchangeably with something called factitious disorder by proxy, but my reading of them is they're pretty much the same thing.
Okay. These intake reports, I'm sorry, I'm going to need you to explain again. You made a distinction.
You asked me a question a minute ago that I didn't answer.
Which was that?
You said, well, you asked me two things. You said, did I see that in the report, and did that affect what I did? I didn't answer the second part because
Thank you.
You told me to stop you. Is that okay?
No, I'd like you to please go ahead.
Okay. No. The answer is no.
Okay.
Except that having 40 years of experience, and I've done probably over 7,000 child welfare system evaluations in Washington, D.C., Maryland, 5 additional mid-Atlantic states, and Florida. Every single case that I've seen where a medical professional thought that a parent had this condition, von Munchausen by proxy, in every single case, there was an underlying either mental disorder or personality disorder or both with the parent. And if it was a child, by proxy means there was also a child involved. In 100% of those cases, the treating doctors had done a multidisciplinary evaluation before instituting treatment, meaning that they did a thorough assessment of possible psychological pain, emotional distress of the child and mother before instituting any kind of more invasive treatments. More invasive would be like ketamine, opioids, benzodiazepines. Why I'm mentioning that in response to your question is that in my evaluation of Maya, which I'm sure you'll get to later, she was telling me some very specific information about her emotional and psychological distress that pertained to her mother. And she was also describing her belief that her mother had a completely different source of psychological distress. So the presence of mental disorder, mental distress, emotional disorders, psychological disorders in a child and parent, those contribute to the diagnosis of von Munchausen by proxy.
Okay, that's a lot to unpack.
Well, I'll make it, here's a simple way to put it. I have never seen a single case of von Munchausen by proxy where either the child or the mother or both did not have some underlying psychological distress, psychological disorder, major emotional condition that failed to be evaluated by the treating doctors.
Okay. And like you said, we'll get to your report.
Right.
I think what you're referencing is during your evaluation and interview with Maya, she allegedly mentioned something about her mother being abused. Is that what you're referencing?
When you say she told me. It isn't alleged, she told me.
Okay.
She didn't allegedly tell me. Is that what you're saying? She allegedly told me that I made it up? Is that what you're saying?
I'm saying there are conflicting reports from Maya Kowalski herself about what was discussed.
Well, I know what she told me, and it wasn't just that she believed her mother was abused. She named the perpetrator. She said her mother was abused by her father in Poland. So she was very specific about not just her belief that her mother was abused, she was abused by her father, and it was causing Maya distress, and Maya attempted to talk to her dad about how much he knew about it, and I quoted that in the report.
So this says, let's read it. We're on page 16. Mother does not have any mental health diagnosis.
Yeah?
I don't see where it says mother has not received any counseling. Do you?
No, so if a person goes to mental health therapy, all mental health professions are required to give a diagnosis for what they're treating. So if somebody went to therapy, unless somebody wasn't following their own ethical code, there's no way someone goes to therapy and doesn't have a condition for which they're being treated.
Do you know what catalyzed Beata Kowalski to attend therapy?
Do not know.
Do you know when that therapy occurred?
Do not know.
You didn't. Did you review records from Eagle Wings Counseling Center?
You asked me that already.
Okay. Do you think it's possible that therapy was related to the family's struggle to deal with the CRPS diagnosis?
Do not know.
So, I know what I was trying to get to here was, back to your lengthy answer a minute ago, which was informative. You mentioned in every case there had been a multidisciplinary team evaluation before diagnosis of Munchausen by proxy. Do I understand that correctly?
No, I was telling you two things. For kids who are being treated for pain disorders, and in this case it was of Munchausen by proxy, there was always a multidisciplinary evaluation. So it starts with a parent is taking a child for some kind of medical treatment. If the treatment involves a chronic pain disorder where more invasive medicines, ketamine, opioids, benzodiazepines are being used, in every single case, the medical professionals would have done a multidisciplinary evaluation to identify any psychological sources of pain in the child or the mother.
Do you know if a multidisciplinary evaluation had occurred prior to your visit on October 18th?
That would had to have been done by, I forget the names of the people you said, Kirkpatrick, and was there a Dr. Hanna? Whoever the treating doctors were, they would have had to have done that, and I do not know if they did or not.
Do you know if anyone at Johns Hopkins performed a multidisciplinary evaluation?
Well, what I was describing is those would have been done at the inception of treatment. So Hopkins, as I understood it, were coming in after the fact of this child having these invasive treatments. So the people that would have done what I was involved in other cases of chronic pain in children or adults, the treating doctors for the child, they would have been the ones to say, we need to look and see before we start giving this child repeated ketamine infusions or giving this child opioids or benzodiazepines. We need to see if this child has sources of psychological pain or if this child has sources of mental distress, or the mother has sources of emotional or mental distress. And by the way, I'm not the first person to insist that there was a link between this child's psychological pain and her physical disorder.
Should that evaluation at the onset of treatment be conducted by every doctor who becomes involved in her treatment?
It should have been by the doctors who were instituting invasive forms of chronic pain management.
Prior to the installation of a PICC line, should the doctor evaluate whether that's appropriate or this is a case of Munchausen by proxy?
That's not what I'm talking about. So this child, before ever going to All Children's Hospital, had seen that I could tell at least three if not four, treating doctors in the community that work with chronic pain. I say the community, I make a mistake. In the Tampa community, there were 2 or 3, and then there was at least 1, if not more, doctors in Mexico. I don't know what their standard practices are. But the doctors who treated Maya for a form of chronic pain disorder and treated her with ketamine, opioids, and/or the benzodiazepines, in every case I've ever seen where a child, or an adult for that matter, was being treated for chronic pain with those medications, those doctors literally always, the cases I was involved in, always involved an assessment of psychological pain in either the child, mother, or both.
Back to the question. The doctor diagnosing CRPS should have conducted that differential diagnosis. Is that correct?
So I'm telling you that every case that I ever had, they always did that. I'm simply telling you that it appeared to be an omission in this case when this child is talking to me about her psychological pain, her perception of her mother's psychological pain, giving details about what she believed her mother's abuse in Poland and that her dad knew and all this stuff that I've already testified about. And in each case, when I asked Maya, had you told these doctors this? And she would tell me, they know, according to Maya, I was the first person that asked her.
Okay.
Outside of her family, outside of her family.
All right, Dr. Lewis, if I understand you, you don't want to make a normative statement and say what a doctor should have done, but you are willing to say that in your experience and based on what you'd seen in the past, the normal procedure was to conduct that differential diagnosis.
So I'm telling you that in every case where there was a child or an adult that was being treated for chronic pain with more invasive medicines like ketamine, opiates, benzodiazepines, that every single one of those cases I was involved with over a 40-year period always had an assessment of the child's psychological pain and or the mother's psychological pain. And in this particular case, in the records you have, I was not the first person to tell somebody that there was a dramatic link between this child's psychological pain and the triggering of intense physical pain.
Okay. The evaluation of psychological pain, that would include the doctor making the initial diagnosis. You would expect that to have occurred. Is that correct?
Maybe more than once.
Okay.
So at the point of a medical doctor going to an extreme chronic pain management remedy to assess, is there psychological pain here with the child or the mother? Are we missing anything? Because psychological pain can cause or contribute to the development of physical pain, or in the case of an actual physical pain disorder where you don't take into account the psychological pain, it can worsen it. So it's either cause or contributing, or it worsens after the fact. At a minimum, at stage 1, yes, it should have been assessed. And secondly, if they see that these treatments aren't working and you're having to repeat more ketamine infusions and more opioids and multiple doctors are doing that, then reassess. See, maybe we missed something. Maybe someone wasn't entirely honest with us.
In every case, and based on your previous experience, where a subsequent doctor became involved in the treatment, would they have also made a psychological pain evaluation?
A subsequent doctor who's giving invasive treatments like ketamine infusions, there were fewer cases that I saw where a second doctor got involved, but yes, the second doctor either did their own assessment or referred the child out or attempted to get the records from the first doctor to see how thorough was this assessment.
What are the criteria in the DSM-5 for factitious disorder imposed on another?
I didn't memorize those.
Do you have a rough outline of what those would be?
There's usually a medical condition that's alleged. I understand that sometimes there can actually be a medical condition, but it's exaggerated. And normally there is a psychological condition in the parent that was not properly taken into account that's causing the parent to either wittingly or unwittingly act this out through the care of the child.
So in diagnosing, and did you make a diagnosis of Munchausen syndrome by proxy?
No, that's a medical diagnosis. I don't make that diagnosis by myself.
I believe the phrase used was working diagnosis. Is that not a diagnosis?
No, what I felt was that in my evaluation of Maya, so I'm finding what I have found in other cases of von Munchausen by proxy, that either the child or the parent or both actually has some identifiable sources of psychological distress or emotional distress that's either causing or contributing to the pain to begin with, or that is triggering relapses of the pain.
Was your working diagnosis Munchausen by proxy?
It wasn't mine. It was a working diagnosis of the doctors in the case.
And your testimony is that Munchausen by proxy, if the diagnosis is made, that is a joint diagnosis of both the child and the parent?
No, by proxy means it's of the parent. But the child, in my experience, you have to look at both the child and the parent together. I want to see what is happening to this child, particularly when I knew that I was not the first person to make the determination that this child had physical pain that was absolutely triggered by specific sources of psychological distress.
Okay, let me be specific. Munchausen by proxy, is that a diagnosis of the parent?
Yes.
Is that a diagnosis of the child?
The child is the proxy, so the child is normally experiencing some kind of reported medical condition, but I'm telling you that they also are typically experiencing some kind of psychological pain that has to be evaluated along with the evaluation of the parent.
Right. I think we all in this room understand that where Munchausen by proxy is a valid diagnosis, that would have some effect on the child. My question is
I'm saying almost not the opposite, but that either you have a child who has psychological distress that's caused by the parent's psychological distress, and that's contributed to the child's pain, or the child's pain is exaggerated by the parent's psychological distress.
okay. Is that a diagnosis of the child?
Diagnosing the child's psychological condition is a diagnosis of the child,
Is Munchausen syndrome by proxy a diagnosis of the child?
of the adult.
It's a diagnosis of the adult,
Right.
not the child.
Not by itself, but you can't do diagnosis of Munchausen by proxy without looking at the circumstances of the child.
Okay, thank you. And also the assessment of the adult.
It should.
Okay. Did your evaluation allow you to assess Beata?
I only was able to assess what Beata had reported in the records that were given to me. I was asked to do an evaluation only of the child.
Could you make a diagnosis of Munchausen by proxy without evaluating Beata?
I don't make that diagnosis no matter who I see. That's a medical diagnosis. First of all, I wouldn't have seen Beata because I had already seen the child, so there would have been a role conflict. That I saw the child, therefore I probably shouldn't also see the adult because I've already formed some opinions. But I did make recommendations based on what I saw with the child that someone needed to fully evaluate whatever the mother's psychological conditions were, and especially if she had been abused. Had she been abused by her father? Did anybody ever evaluate that? Where did this child get that from? Because it was clearly disturbing the child that happened.
You mentioned you wouldn't make that diagnosis in any case. Is that correct?
I do not make the diagnosis factitious disorder by proxy. I defer that to a physician.
What type of physician?
Any doctor who feels capable of making the diagnosis there. I don't know their ethical standards. I've seen psychiatrists make the diagnosis. I've seen pediatricians make the diagnosis. I've seen neurologists make the diagnosis. I've seen doctors in multiple professions make that diagnosis.
Do you have any expertise in ketamine?
I'll tell you what you said any experience?
I said expertise, but we can talk about experience as well.
Okay, my experience with ketamine, I had two experiences in my professional life dealing with ketamine. One was when I was the principal investigator of a National Institute of Health grant investigating PCP and polydrug abuse. Ketamine is a chemical cousin of phencyclidine. So PCP stands for phencyclidine, piperidine, hydrochloride. Ketamine is a cousin of PCP. When I was the principal investigator of this grant, and it ended up being published as a book chapter, I was seeing people who had polydrug abuse, and this is still happening to this day. Kids, teenagers, middle school, no elementary school kids that I saw, college students, were abusing it. So that was part of my professional experience with ketamine. The other part was a small number of doctors were using ketamine infusions to treat CRPS or RSD but they were mostly not using ketamine. So maybe a handful of people before this case had I seen any age of patient being seen for multiple ketamine infusions.
Okay. But you had encountered the treatment of CRPS with ketamine.
A small number, maybe less than 5.
Okay.
And they were adults.
And based on this polydrug abuse and this other research that you did, what do you know of the withdrawal symptoms of ketamine?
Well, first of all, some of the cases that I saw were family members who would say siblings that were all abusing it, and one of the siblings had overdosed. They were fatal. There were fatalities. And so a group called DICAP, Drug Intervention Counseling Action Program, was referring the siblings to me. It was difficult for me to say what the withdrawal was because none of them were single substance abusers. They were using other things too, PCP, cocaine, marijuana, alcohol.
In what capacity were you brought in here?
In what capacity? I'm a consultant to the Child Protection Team. I was asked to see Maya at the hospital, and I defined my role as administering, scoring, and interpreting various tests with her, doing a clinical interview, and if I heard or saw evidence of trauma with her, I interviewed her about any traumas that she experienced, and then write a report and send it back to the Child Protection Team. That was my function.
You work for Suncoast, is that correct?
I'm a consultant for Suncoast. I see 12 kids a year. I have an agreement that I will see 12 children a year through the Child Protection Team.
Okay. Suncoast, is it fair to say, is a contracted lead agency?
Not the way you're using it. So there's community-based care organizations. There's 18 of those in Florida. Those are Department of Children and Families subcontracted agencies. That's DCF. The Child Protection Teams are under the Department of Health. As far as I know, I'm not privy to this, but as far as I know, Suncoast has a contract with the Department of Health to provide a child protection team. As far as I know, Suncoast has numerous other programs as well, but that's only one. They do mental health therapy, they do sex abuse treatment programs, education of the community, so they have multiple functions.
All right, how long did this evaluation last?
I was with Maya somewhere in the neighborhood of 3 hours. Right.
It also says referred by Dr. Sally Smith. In what way were you referred by Dr. Sally Smith?
Because the Child Protection Team normally will refer a case to me either on their own or Dr. Smith directs them to contact me to see the child.
Okay. On how many previous occasions prior to this 2016 evaluation had Dr. Smith directed the Child Protection Team to involve you?
Okay, so I have been doing Child Protection Team CPT evaluations since the fall of 2013, so not quite 6 years. And my agreement with them is that I'll do 12 a year. So what's that work out to? 12 times 6, 70 or so. And more likely than not, they were ones that Dr. Smith recommended they call me. Sometimes there's a nurse practitioner on the team that will say, you should get Dr. Lewis involved in this one, or the Child Protection Team is involved with the Child Protection Investigator, and the CPI will say, hey, we need to get Dr. Lewis involved. So I really can't give you a number. I'm not 100% sure how many were just from the CPT through the nurse, or from the Child Protection Investigative Office suggesting they get me involved, or Dr. Smith.
In the last paragraph on page 1 of your report, you mentioned the very problematic dissociative anesthetic ketamine. Are those your words, or does the description of ketamine come from the intake reports?
My words.
And please describe what you mean by very problematic dissociative anesthetic.
What I described to you earlier, my experience with ketamine and reading about it and having kids overdose on it and doctors being reluctant to use it.
So again, that would be the risk of overdose, correct?
Psychological dependence.
But it doesn't refer to any specific withdrawal effects.
No.
Okay. On the second page of your report, the first full paragraph on that page mentions that the all children's staff and CPT Medical Director Smith developed significant concerns that Maya has been the witting or unwitting subject of Munchausen syndrome by proxy. Who are you referring to specifically on the all children's staff?
That was just my interpretation of reading the records.
Okay, so you don't know who specifically within the hospital had those
No.
concerns? Okay. And you say that Maya has been the witting or unwitting subject of Munchausen syndrome by proxy. What would it mean for Maya to be a witting subject of Munchausen syndrome by proxy?
That the mother was doing it wittingly and not unwittingly.
Oh, so it's a description of the mother's,
Right,
okay, mother's state of mind, not Maya's state of mind.
right.
Okay. The third paragraph, further anecdotal reports indicate that the parents were able to convince at least one hospital to treat Maya with morphine. These anecdotal reports, do you know the source of those?
The records that I was submitted,
The intake reports.
yes.
You're not aware specifically who provided those reports?
No.
The last sentence of the third paragraph, these medications are known in the neuropsychological literature as causing or contributing to significant neurodevelopmental difficulties if misused or if used instead of far less invasive, restrictive treatments. Were you aware that the ketamine was prescribed by Maya's treating physicians?
Just from what I read in the record.
I understood. Your understanding of the case is that Maya experienced a period of distress, and then that brought a flare-up of CRPS. Is that right?
You asked me where I got that
No,
particular...
I'm not asking where you got it. I'm just trying to understand if I heard you correctly.
Well, the second part of my comment was that I was not the first person in the case to definitively say this child had psychological circumstances that caused extreme relapse and severe pain.
Who was the source of that comment, if you recall?
Your client's wife.
Okay. You're referring to Beata Kowalski.
Yes. So if you go to 015, and it says, the mother reported that 4 weeks ago is when the last relapse began. She believes the trigger was when hospital homebound program denied the child services. The mother stated this was taking away the child's line to reality to classmates and teachers. The denial of homeschooling caused the child to have an emotional depression. She experienced distress, which led to a flare-up of pain. Okay, so I was making two statements there. The mom was informing the child, you can't get this hospital homebound program anymore. And the mom is then noting in her belief system that that is what caused the child to have intense CRPS pain.
I'm sorry, did you just say that the mother delivered that information to the daughter?
I got that from talking to Maya. But even in that paragraph, schools don't send letters home to children. Whatever the notice was that the parent received, so a parent would receive notice, your request for hospital homebound has been denied. So the parent would have to be the one informing the child that that was the case.
And so this distress that the mother describes, how does that support or cut against a diagnosis of Munchausen by proxy?
Well, so the mom was in distress, and the mom conveys to the child, I'm upset that you can't have this program. According to the mom, the child learning of this denial of homeschooling triggers, according to the mom, this intense flare-up of CRPS that she did not have until she was informed of this information. That's why in my report I'm saying unwittingly instead of wittingly. So it may not be that the mom knew or understood and may never have had a discussion with a treating doctor. You mentioned this Dr. Kirkpatrick, and may have never have had a discussion saying, you don't tell this child distressing information because it could cause her symptoms of flare-up, then we have to give her this invasive drug. So what you do is prevent that from happening. Instead of giving her a bunch of ketamine, Mommy, you're being counseled now by the treating doctor. This child's pain, we know, can be triggered by information that produces psychological distress. So don't give this child psychological distressing information or let her overhear it between talking to you and your husband. Those are the cases that I've had it with chronic pain in the past, that we advise people of that. But that would have been the treating doctor would have had to have done that. I don't know if he did or didn't. So either he told the mother, don't do this, and she did it anyway, or he never told her. And she would know, oh goodness, I'm making my kid's problem worse, I'm making her pain problems worse, and having her go back on ketamine because I just gave her information that I was distressed by. Now the kid's distressed, and according to the mom, that was the single factor that caused this last flare-up before Children's Hospital.
So as you reviewed these 20 pages ahead of October 18th, you wouldn't have had any independent knowledge that the mother was distressed other than what you read into this paragraph?
Right. And from what Maya told me, that's the most important thing. What I got directly from the child, I did a pretty thorough assessment of her, a clinical interview and a trauma interview, of what exactly was making Maya sad, upset, anxious, worried, or depressed. And she described she was worried about her mother. She was depressed because she knew her mother was depressed, at least she thought. She thought her mother was depressed because her mother had been abused by her own father. Maya was also traumatized by in her hearing a doctor in Mexico telling the mother, Maya has a 50-50 chance of dying from these treatments. And that further traumatized the child. So that was all part of my doing an assessment of what her psychological pain was.
Does it mention that the mother was distressed?
It's an inference. The way that she reported that to the team, she believed the trigger was the hospital homebound program when the child was denied services. Those several lines there are describing mom was upset that the kid was denied services, and she was upset that then that triggered the child having a pain disturbance. What she didn't recognize, likely, is that it wasn't the fact of the kid's service being denied. It was mom telling the kid, in the mom's being upset about this being denied, and telling the kid, you've been denied this program. And then the kid has a major flare-up of pain. And I'm concerned that a medical doctor providing these medicines never told the mom to be very careful about not sharing any of that information with the child, much less doing it when she's upset.
The mother's distress was an inference of yours based on reading that paragraph?
Partly, and partly from knowing that Maya had told me repeatedly that she was upset because she felt that her mother was in a state of distress and her mother was depressed about multiple things.
How could the family have avoided telling Maya that she couldn't attend the hospital homebound program?
It depends on how they told her. If mom was upset when she told her, and it turns out in interviewing Maya, she was very sensitive, more so to her mom. She only brought her dad up a few times. She was very sensitive to when her mother was upset. So when I'm reading that, it was evident to me that this was not a calm moment. This mom is upset. These people didn't give this child something the mom believed she should have given her child. And unless the mom was counseled properly, to go off, calm down, let the child know, you're not going to get this hospital homebound program, but we're going to find some other way to teach you. And if she told her in any kind of a state of distress, this child is very sensitive to her mother's psychological state.
Dr. Kirkpatrick or Dr. Hanna should have counseled her to calm down before delivering that message?
The treating doctors in this case, and again, I don't know what they did or didn't do. It's always been my experience that treating doctors would assess, does this child have psychological distress? Does the mother? Is part of the child's distress her perception of mom being depressed or upset, not just about her condition, about mom's depressed because she was abused by her dad. And this child, in talking to me, is very sensitive to what she thinks her mother's emotional states are. In actuality, the child's describing to me what could have been a major depression on the part of the mother that pre-existed all of this taking place. And that could have been identified at the inception of the child's treatment.
Back to the third paragraph of your report on page 2, you mentioned far less invasive restrictive treatments. I assume those are CRPS treatments you're referencing.
Well, the less restrictive treatment are psychological remedies and psychological treatments.
Is CRPS a psychological disease?
No, but that's what we've been talking about. In cases of chronic pain, when there is a psychological disorder or psychological distress identified in the child or mother, and you treat those psychological issues, the pain management patient needs less medicine.
So treatment, a psychological treatment of Maya would have lessened her pain?
Identifying what I identified at the time I identified, had that been done prior, that somebody came along and found out Maya's worried about her mother. She's worried that her mom's depressed. She's worried her mom's depressed because she was an abused child by her own biological father. Maya then is affected by her perception of her mother's upset. All of those things are contributing factors in chronic pain cases. My experience has been, and this is in the literature too, when you treat mom, dad, child, the psychological issues in the family, you treat those, you identify those, and then treat those. At that point, the amount and frequency and levels of medications are far less than if you ignore it and don't even check that it's there.
All right, the first sentence on page 3 says that Maya at no time spontaneously initiates any verbal expressions of pain or cramping. Are spontaneous expressions necessary to support a CRPS diagnosis?
So what that sentence is referring to, because I knew I was sitting with a child who was reported to have a chronic pain condition. And as I told you earlier, I knew that adults who had those conditions can't do like a high five. You shouldn't. They could have pain. They could hurt them. So I told Maya before I started administering any of the tests, if you have any pain, if you are uncomfortable, if you're hurting when we do any of the tests today, I need you to immediately tell me that, initiate that, tell me that. And after giving those instructions, she did not do any of those.
Okay. You go on to document and correct me if I'm wrong, an above average IQ.
In some areas.
Okay, and a processing speed deficit.
Relative deficit.
Okay, explain relative deficit, please.
Okay, so in interpreting these test batteries, a child can be relatively high or relatively low in an area in one of two ways. They can be relatively high or low compared to children in their own age group. We say the middle of the average range is between 90 and 109. So a child could have a 60. So that would be relative to her norm, she's very low. You can also be relatively low or high compared to yourself. So in Maya's case, her highest score minus her lowest score was 37 points. Even her lowest score, if you look further in the report, even her lowest score was down in the 90s somewhere, 85 to 90. So her relative weaknesses were in relation to her own strengths and only marginally low relative to the norms for her peers.
I'm now on the fourth full paragraph on the page. Seems that it's one continuous sentence, so let me start halfway through. Her obtained full-scale IQ of 109, uppermost point of the above average range, should be cautiously interpreted as representing a likely underestimate of her true or potential functioning that should occur after she has a continuous period of non-narcotic, non-opioid medication, and no return to the dissociative anesthesia medications that she was prescribed in the past in Tampa and Mexico. Which drugs were you concerned with when you wrote that?
Okay, so what this true IQ means. So I'm testing a child who was giving various types of medications. They can affect how a child's functioning. In her clinical interview, she also described to me that she had the subjective experience of processing problems with memory. And she told me on her own that she heard the doctors and her mom talking about that ketamine can affect her memory. So what this part of the report says, if this child were retested at a point where she had less invasive medications, her psychological issues are treated, it's very possible that her full-scale IQ would be higher than what I obtained.
And which medications were you concerned about?
Really all of them and the interaction between all of them.
And when you say all of them, what medications?
The ones that I mentioned there. I know ketamine itself can affect memory. The opioid and benzodiazepines all have central nervous system side effects. They can affect psychomotor speed, graphomotor speed, processing speed.
How long will the effects of those drugs linger?
They all have different half-lives, and it depends on how much they're... So how long a drug, as you put it, would linger depends on how much you're giving over what period of time.
Did you attribute her relative processing speed deficit to the drugs that she'd been on?
Not by itself. So further in the report, I say that in several places, some of these relatively low scores could be the medication itself, or it could be the psychological distress that she's having, that those can also affect the scores on these tests.
You mentioned a second ago that there could be other causes for the processing speed relative deficit. And I think you threw out a broad category of psychological pain.
Well, anxiety and depression
Okay.
associated with psychological pain can cause those things to be low. Lots of kids that I see that have PTSD, for instance, have had traumas, that some of those scores are relatively low.
And correct me if I'm wrong, but I think a second ago you testified you had no way on October 18, 2016 of separating out the effects of the lingering effects of ketamine and the other drugs versus the psychological pain basket of things that were affecting her processing speed.
Right.
So that psychological pain, that would include potentially, would that include pain from CRPS?
No, that's physical pain.
Okay.
So when I interviewed Maya, she described that she was worried about what she perceived as her mother's distress. She's also traumatized by hearing, or what she believed that she heard, that she had a 50-50 chance of dying as a result of some of these treatments. She also felt really badly about hearing how much money her parents were spending. All three of those things were causing her worry or depression.
Okay. You've mentioned several times today that she overheard this conversation about the risk of her dying from the ketamine treatment. Have you become aware at any point that her statement is that she was directly told about the risk of dying?
It's what is in the report at the top of page 7. She said, I heard him. And I believe at that point, she's referring to the doctor in Mexico. I heard him telling my mother that she, her mother, had to sign papers because the infusions had a 50% chance of killing me. Those are Maya's exact words to me.
I understand that your takeaway from the conversation was that she overheard that from Dr. Cantu.
It wasn't a takeaway. She said, I heard him telling my mother.
I can't testify to exactly which were the last day she saw the mother on. All I know is that no contact order was entered on October 14th,
Right.
and your evaluation took place on October 18th. So 4 days of separation at a minimum. How would that affect a child's emotional status?
I've never seen that happen, where a child hadn't talked to a parent for several days, and that by itself was causing a child such significant psychological distress that it would affect their testing. Lots of the kids that I see, for whatever reasons, don't see their parents. One travels out of town, one got put in the hospital for whatever reason. You know, it happens all the time that kids have days at a time where they don't see or talk to one of their parents. I've never found that to be something that would cause effects on their testing.
Would hearing that news comprise significant psychological pain such that her processing speed could slow down?
I can tell you this, I carefully interviewed this child. She never once brought up to me, and I was sitting there with her, she brought up lots of things to me about her mom, including this worry that her mom's depression was related to, which she perceived as her mom's depression was related to her being abused by her father. This child never once, and she had many, I said, do you want to ask me anything? And many times I said, do you want to ask me anything? And I would ask her questions. At no time did she say, when exactly am I going to get to see my mom again? She never brought up to me that she wasn't seeing her mom or when she was going to see her at any point. It never came up. She never mentioned it. So if it was bothering her, she'd never mention it. She did tell me lots of other things that were bothering her, but that wasn't one of them.
Did you find Maya to be depressed?
Yes.
And when you said it needs to be shared with a consulting pediatric neurologist, who did you have in mind?
I didn't have anybody in mind. I was recommending in more than one place in my report, I felt that a neurologist could do, an independent neurologist with no financial stake in her case, that wasn't going to make money from giving her pain management drugs, could render more independent opinions about the course of treatment, what's going to be best for her, what took place before before I saw her, what's the best course for the future.
And are you aware if a consulting pediatric neurologist at Johns Hopkins ever carried out this task?
I wasn't saying that had to be done at Johns Hopkins. I didn't know when the child was going to be out of the hospital. I didn't know if it was something that the family could do.
The important point was that they didn't have this neurologist wouldn't have a financial stake in the case. Is that correct?
Well, in that they wouldn't, the same doctor who would be diagnosing this or not diagnosing it or making a treatment plan wouldn't also be making $10,000 a pop to give her ketamine infusions.
And without reviewing these reports of Dr. Chopra and Dr. Duncan, you're not aware as to the ultimate opinion of a consulting pediatric neurologist?
I mean, my opinion was that, so to use it in different language, at the very beginning of inception of treatment by the two treating docs, Dr. Kirkpatrick and Dr. Hanna, that there should have been a multidisciplinary approach to this case before the inception of treatment. And I would still recommend that now.
Did you ever discuss this with Dr. Smith following your evaluation?
I already told you I never talked to Dr. Smith about this case.
Am I correct in concluding from your testimony today that you've never discussed your evaluation of Maya with anyone from All Children's Hospital?
Right.
This concludes the deposition of Dr. Jim Lewis, PhD.
Okay, thank you very much. Okay, members of the jury. There we go. Got the lights back on. That is going to conclude the jury's involvement today. So that means you're going to get to go home in a couple of minutes. I just want to let you know we are still on track. So just kind of give you a heads up, we are still on track and to finish by whatever I said, the 8th or the 9th, whatever that Thursday is of November. Please do not discuss this case amongst yourselves. Do not do any investigation. Receive no information. As a reminder, you will not be here on Wednesday. So that's a planned day off. Tomorrow, I think, is going to be a full day for you. So let's have them back here ready to go at 9 in the morning, and we will see you then. Thank you.
All rise.
Okay. The jury is out of our presence. Do we have the running time? Everyone can sit down. Do we have the running time for Dr. Lewis?
It's 48 minutes and 3 seconds for the defense, 9 minutes, 32 seconds for the plaintiff, and 4 minutes and 30 seconds of overlap.
the consumption of time today, the plaintiffs consumed 55 minutes. Their running total is now 44 hours, 30 minutes. The defense consumed an hour, 15 minutes, and their running time consumption is 16 hours. So the next thing we have is directed verdict motions. So you all want to take a few minute break. And just as a reminder, the last person that speaks isn't the one that necessarily wins, so don't feel like we need to keep going back and forth on these. I'm assuming Mr. Altenburn and Mr. Elegant will be the main people arguing. I mean, certainly I've been letting other people continue to chime in, but you know, just remember, it's just not the last person to talk. So, Ms.
Judge,
Crowe.
different issue. Is it possible, I understand, you know, whatever the court decides, to do some of defense exhibits that we didn't get to this morning before we do the directed verdict motions, or do you want to get into the directed verdict?
I want to do directed verdict motions
Okay.
if there is daylight after directed
All right,
verdicts.
and we can do it in the morning then if not. Okay.
Well, I mean, if there's, you know, I don't know how long these are going to take, but, you know, if we finish directed verdicts before 5 o'clock, then sure, we can talk about it. If we finish directed verdicts after 5 o'clock, then
Do it in the
I'm
morning.
probably going to want to
Yeah.
do it tomorrow.
That's fine, Judge.
Can we approach just on point?
Okay, we're going to take a break. Why don't we be back at 3 o'clock, which is about 12 minutes from now. Okay, we'll be in recess, and then we'll do directed verdict motions.
All rise, court in recess.
Mr. Altenburn, how are we going to proceed? Are you going to go like count by count, or just kind of give me a preview of how you're going to do this?
I'll give you my preferred order, and then you can change it if you want to. But I would like, the heavy lifting in this is the intentional infliction of emotional distress counts, all three 21s. And so I would like to do those first and take as much time as we need to do those. And then there are 4 that I think go faster, which are the 2 negligent infliction of emotional distress and the 2 fraud counts. And so I'd like to do those and then kind of follow through the outline then, because medical malpractice, which is short, but Sally Smith, I want to see if I can get that Dr. Smith under control and count 14 rolls with that. And at that point, I would jump back to the very beginning to battery and false imprisonment, because that also deals with the punitive damages part.
So we're jumping around.
Yeah, a bit, yes.
Okay, are we ready to start?
If you don't mind, I'll do it from a podium. I've been sitting for 2 weeks.
Yeah, that's fine. You've been sitting in the uncomfortable chairs too.
Yes, sir, I have. So the first 2 motions are going to be the motions for directed verdict on the claims of the estate of Beata Kowalski for intentional infliction of emotional stress, counts 21A and 21B. It's a survival count and a wrongful death count based on intentional infliction. You know, I want to address these first because, as I say, I think in terms of getting things right in this trial, these are the most important counts. I think you already know the standard applied to a directed verdict, and I won't repeat that unless your memory has failed you. But I would point out that, as we've discussed before under Baker versus Florida National Bank and in several other cases, there's an emphasis that this is a little bit different because the question of whether something arises to the level of intentional infliction of emotional distress is regarded as a legal question rather than a factual. And that's because there are a lot of policy reasons why there should be kind of a gatekeeper on this before it goes to a jury.
I think I was kind of alluding to that this morning.
Yes, yes. And of course, that can be done on a motion to dismiss, but it can also be done on a motion for directed verdict. And I'm not going to discuss the case law with you because I think we plowed this a lot, but I will emphasize that the standard for directed verdict is discussed in Kim versus Chang, which is 249 Southern 3rd, 1300. It's a second district court reversing a trial court that failed to grant a directed verdict. And you've already discussed even out loud during trial here the Liberty Mutual versus Stedman case from 2007, which is the one where they said it stood for a situation where an insurance company declined to authorize a double lung transplant even after ordered to do so. And the same year was the Galagui versus Rodriguez case, which is 970 Southern 2nd 470, which is the case where the second district indicated they were assuming the truth of the facts in the complaint, but the complaint alleged that police officers were intentionally running an organized drug or out of someone's bar and threatening the bar owner. So the elements of this are basically threefold. You have to have an intentional or reckless conduct, and that conduct must be extreme and outrageous conduct, which is behavior that under the circumstances goes beyond all possible bounds of decency and is regarded as shocking, atrocious, and utterly intolerable in a civilized society, civilized community. And that conduct must cause the victim severe emotional distress. To be severe, that stress must have such intensity or duration that no ordinary person should be expected to endure it. It's a reasonable person standard, not a specific person standard. And the causation here is a but-for causation, that the extreme and outrageous conduct is a legal cause of emotional stress if it directly and in natural continuous sequence produces or contributes substantially to such severe emotional distress so that it can be reasonably said that but for the extreme and outrageous conduct, the severe emotional distress would not have occurred. Now for count 21B, we know we haven't quite landed on the exact language, but there's a next step, and that the extreme and emotional distress must be such that it is a legal cause of suicide. We've discussed the substantial factor test and the irresistible impulse test, but at this point, I don't think you've committed yourself to exactly how we're going to use that test. At the beginning of this, what I want to point out for both of these is that if you analyze the evidence that's actually come in as compared to what was pled as to Beata Kowalski and her relationship directly with the hospital, I don't think that any of the standard elements have been established in this case. The evidence on this is actually quite limited because it didn't start at the end of communism in Poland, whatever year that was. It begins on October 7th, 2016. And that's when Maya Kowalski arrives in the hospital with her father, Jack Kowalski. And the testimony concerning that first week of the event is almost exclusively from Jack Kowalski. There may be a little bit from Maya Kowalski, but she was 10 years old and needing to be in an ICU unit at that time, so there's not too much testimony from her. So we don't have any testimony that's been presented by a doctor that's employed by the hospital or any other witness here. We have no third-party witnesses to what went on in that third week. And so Mr. Kowalski says that he took Maya to the hospital on Friday morning about 8 o'clock, and they were there because they had been in Pinellas County already to see Dr. Hanna, who we know had given her the ketamine treatments for 2 days preceding that at high dosage. And Beata Kowalski arrives at the hospital sometime soon thereafter, and it's pretty clear that she sort of takes the role of principal parent to discuss these things with the hospital. Maya was in pain and thrashing about, and Beata was upset, and Beata wanted ketamine treatment to be continued at the ER or in the pediatric intensive care unit. The hospital didn't want to do that. And as a result, Beata eventually wanted to take the child out of the hospital with the theory that she was going to see Dr. Hanna. Now, Dr. Hanna hasn't testified in this case at all. We've got his medical records in, but that's all we have here. We know that there was apparently an appointment scheduled to see him, but there's absolutely no testimony that he would actually have been willing to give this child ketamine, even if the child had been taken out of the pediatric intensive care unit and taken to him. Now, so at that point, when Beata wants to take her home, the testimony right now is that someone in the hospital threatened to arrest them, and they changed their mind. Now, and of course, you have ruled, and I won't go through the rest of this, that at that point in time, everything the hospital did in terms of reporting this to DCF was done in good faith. And in that process, you know that the hospital contacted Sally Smith, who had a background in medical child abuse and was the head of the CPT team in Pinellas County, and also happened to be a member with staff privileges at the hospital to get advice about child abuse. Not that first day, it wasn't so much to be treatment, but whether what we're seeing is medical child abuse. At that point in time, or within a day of that point in time, she is assigned the duties to investigate this for the CPT team. And at that point, she comes to the hospital for an interview with them, and within a day, the shelter proceeding is filed and there's a hearing in court. Now, whether there was medical negligence that took place in that time period, or maybe a false imprisonment of Maya under this, assuming that that was sufficient for false imprisonment, the question is whether the things these doctors did in that time period goes beyond the bounds of decency and regarding as shocking, atrocious, and utterly intolerable in the civilized community. And respectfully, I think doing anything but what they did would have had moral issues more than what they actually did. To that point in time, I don't think there's a single act that they can look at, or even a collection of acts, and say, this fits within intentional conduct or reckless conduct that in some fashion causes severe emotional distress because it's extreme and outrageous conduct. I just don't think it's there at all. Now, after the hearing, Beata is no longer in the hospital. She's at home, or at least she's away from the hospital. From that point in time, there is the testimony on this is, of course, that she never experienced extreme or outrageous conduct in the hospital itself. There's nothing direct one-on-one except for the contact with Kathy Beatty that allegedly or by the evidence takes place on these telephone calls. So we know it doesn't happen in the hospital on a one-on-one basis. The only testimony about her stress during this period comes from Mr. Kowalski. He said it again today. Basically, he'd come to the hospital, which he did on a regular basis, and he'd go back home, and apparently either by cell phone in the car or when he got home, he'd tell his wife what he learned. Now, he doesn't say that he did it in a fashion that caused extreme distress. I'm sure, as he said, it was upsetting to her, but upsetting isn't the test that we need for this tort. And so, I mean, I think we have to presume, and I think the evidence supports, that Mr. Kowalski didn't do things to make her extremely upset in that situation. And I certainly don't blame him for having done it in the fashion that he did. But what we do know in this time period between the 13th of October and when she commits suicide, that she did not see a doctor or a priest who testified that she was in this kind of severe distress. No doctor or priest told the hospital about any distress or told the jury anything about this. She only saw Dr. Duncan, and that was for forensic testimony that was ordered by the judge in the shelter proceeding. And Dr. Duncan was up here. She testified that the hospital was reasonably cooperative with her, letting her interview Maya in the hospital, that she talked to Beata, and that she saw no signs of extreme stress or suicidal ideations herself. She had no friends or neighbors that told this jury that she came to them saying that she was terribly, terribly upset. And Mr. Kowalski did not come back to the hospital and tell them that she was in extreme emotional distress and that they had to somehow do something to get her treatment care or do something that they could do from where they were compared to where she was, since she couldn't enter the hospital. So during that time period, if you look at the conduct with her, the notion that there's intentional or reckless conduct by the hospital that causes stress, to the point of whether it causes stress, the evidence is not there. We know that Beata Kowalski did not view the videotape from the EEG room, although she certainly was aware of it, at least from the point in time when her lawyer obtained it from the hospital. And it's undisputed that she did not hear or see the photographs that were taken on the day before, apparently before she committed suicide. So while that may be a factor as to Maya, it's not something that plays a role in trying to decide whether the hospital is guilty of intentional conduct or reckless conduct against Beata. Now, the supervised telephone calls clearly upset her. Now, it's clear from the testimony that at least somebody from DCF was on those phone calls as well. So the fact that there are people listening in is maybe an invasion of privacy, but that's not been alleged in any count ever in this complaint. And the notion that they're using Miss Beatty's phone and that this is taking place, the phone call itself or her position certainly is not outrageous conduct. You've listened to the phone calls where they say that she was interrupted by Miss Beatty. That could be rude, could be impolite. I'm not sure what you want to call it, but there's lots of cases that say that being rude and impolite and those kinds of things is generally not something that rises to the level of extreme and emotional distress. So I do not think those phone calls by themselves or in combination with what we're seeing here are enough to rise to that level. Now, in the final week
And we're talking about, I just want to make sure I'm understanding.
Yep.
Your argument is to count 21A and B, the survival action and wrongful death relating to Beata, and we're not talking about.
That's right. We'll move over and talk about that one later. And to a certain degree, I'll point out that, well, even if you look at that as well, indirect as to her, there's a lot of things there that go on that may not be pleasant, but whether they arise to this standard is perhaps another question. But right now, I'm just looking at Miss Beatty, with Miss Kowalski directly, because I think under the law, and when you look at all the other cases, it's always been direct conduct and not something that is a game of telephone where he said that causes stress. So under this theory, I think it has to be direct and intentional or reckless. Now, in that final week, there really isn't much evidence at all of anything that she knew about or contact that she had that upset her from the hospital. What we do know is that on Friday, she goes to a court hearing. That's the hearing where the judge is giving her an opportunity to prove that she didn't, not to prove, but to have the DCF have the burden by preponderance of the evidence at that level to prove that she was guilty of medical child abuse. It's going to happen, I think, 4 weeks later. She wants to hug her child. Her lawyer requests that. The judge says no. And she goes home and within a very short period of time writes 2 suicide notes that I believe had been put into evidence. I think they were up on the screen, if I recall correctly. And those notes are to the judge, not to the hospital. Admittedly, they complain about some people at the hospital, but the person she's directing them to is the judge. And then she leaves home for a while. Whether she had a gun with her or not, Mr. Kowalski thought she did. He reported this to the police, but he didn't try to Baker Act her. He didn't try to get any help for her from a counselor of any sort at that point in time. He said he thought she was depressed, but he didn't think she was suicidal. And he was there. And then the next morning they get up, and the testimony is that she wraps a birthday present for someone that they're going to a party, I think, still in the same community. And everybody else in the family leaves her home, and they go to that party. Now, I don't think they would have left her home if they thought that she appeared to them to be suicidal at that point in time. And when they come back, they don't see her, and they don't look for her in the house. Presumably, she's already hung herself, or choked herself, rather, in the garage, but I suppose it's at least theoretically possible that she was away from home and came back later that evening and did the same. And I don't want to dwell on the detail of the suicide, but, it was not a spontaneous act. It took a fair amount of planning to do it the way it was done. It was a choking, not a hanging. Her toes are actually on the ground in the pictures at the end when it's investigated. So it doesn't look like something that was done impulsive by someone who simply picks up a gun and pulls the trigger or takes a knife and slits their throat. This is to the extent that suicides are reasoned out, this is a reasoned out suicide. Now, all of this is simply not a prima facie showing of an intentional or deliberate or reckless conduct that is directed at Beata. And assuming that it is, whether you look at these in individual or you try to, you can't simply add up a dozen things that don't meet this standard at all, or especially things that are negligent or rude, and transform them into a period of intentional infliction of emotional distress.
Mr. Altenberg, let
Yep.
me ask you this. Do you have case law, or can you point to case law that talks about the conduct has to be direct versus indirect for intentional infliction of emotional distress?
I don't know that I have a case that expressly addresses that, but when you look at the cases where they say it is enough over and over and over again, it's, we refused to give you a lung transplant. We hung out in your bar and pretended we were running, or we did run, a drug ring. We do things quite directly to you. Certainly in the initial case, they refused to give insurance coverage to something, although in the original case in this, it was found not to be sufficient to be intentional infliction of emotional distress. So all I can say is from the cases that I've given you from around the country on suicide and on these, the ones that rise to this level are in order, and I think it's because you have to intentionally want to do this or recklessly do it under the standard of, you know that there's a high probability you're going to cause harm to this person. And that's very hard to do on some indirect fashion when they haven't been inside your hospital for about 90 days at the time of these events. Now, the causation problem in this case, if I can go on to the issue of causation, is also a difficult one because of what you've been struggling with for 2 weeks with Chapter 39. Everybody knows that this woman was very upset and understandably upset because her child is in the hospital and she can't see her, and the government has taken this person, her child, away from her for more than 3 days. 3 months. It's going to be another period of time until she has a final hearing. And yeah, she's very upset about that. And as the doctor on the stand this morning said, things that happened in the 24 or 72 hours before a suicide are critical, and what happened to things in the court. Over and over again, we're seeing that the thing that seems to be the strongest cause here are things that have been ordered or under the control of the court and not under the control of the hospital. So the fact that, Maya on the stand the other day, I want it out, I want it out, I want it out. Frankly, the hospital was wanting to transfer her early on to some place that had a unit that could care for this problem better than they could. And unfortunately, that simply didn't happen. We've heard a lot through this that was told to the jury about they did this and they did that in connection to this claim and others. But so often that they is a combination of either the hospital and DCF, or sometimes it was only DCF. So my position is that neither one of these claims reaches the level to be an intentional infliction of emotional distress. When you jump to suicide, you've got that next layer of things. And again, what you heard this morning, irresistible impulse and substantial factor, by the way, aren't really terms that are psychiatric. They're legal. And I would submit to you that in this circumstance, when you think about this tort, it's a but-for causation and ought to be the substantial factor as compared to a substantial factor. And when you start looking at this, the substantial factor for a suicide a day after the court hearing, after 100 days of court, was the court and not anything that was done that may have been rude, impolite, or medical negligence, or more than that in the hospital. So I believe we're entitled to a directed verdict on both of those. If you want me to, I'll stop now, or I can go on to Maya.
I'm going to have you stop, but I want to say push back, but I want to clarify because I don't think it changes your argument.
Okay.
But I think you said that I had found the report, the abuse hotline report, to be done in good faith. I think what I had found was that there was a reasonable cause for the report, and under the existing case law, I did not have to get to the issue of whether it was done in good faith. I think my statements in the order that we were talking about was that I questioned whether the cases that I have to, and I'm legally bound to apply, whether they were wrong. And I think they were wrong on the question of good faith, because I think because the statute said good faith twice, but because Judge Padovano in that first DCA case had said what he said, I did not go there because I'm bound by that. So right. I don't think that changes your arguments, but I wanted to make sure that didn't, because. And
you are exactly correct in what that order says. I would submit to you that evidence also established good faith, but I know that you didn't reach that. You reached what you thought the law required under the cases from the first district. So I didn't mean to misstate that. No, and I wanted to make sure that it didn't change your argument. Nope. And I didn't think it would. I just wanted to make sure. Is it going to be Ms. Ferrier or Mr. Elliott? Who's going to make the argument?
welcome to stand if you want to keep standing, or if you want to go back and sit, that's
You know
fine.
what? I've
Whatever
been-
you want
I've
to
been
do.
Sitting for so long. Feels good.
Thank you, Your Honor. Tom Elliott here with my partner, Amy Ferrier. Let me start sort of near the end, because one of the things I heard toward the end was, it seems to be. It seems to be means that's a jury question. We're here on a directed verdict. No questions, nothing for the jury to decide. And when I start hearing, it seems to be these other things were the major cause, that's their call. That's their call. Now, suicide, well, again, kind of working backwards. Your Honor has already ruled. I've seen the transcript. We had the argument. You announced that the question would be, did John Hopkins cause Beata Kowalski to act on an irresistible impulse resulting in her death, or was John Hopkins' conduct a substantial factor in the death? And that is consistent with the standard jury instruction for the issues that will come before the court, for the jury. Legal cause, you heard the first legal cause, A, read, it's 410.6, but B is concurring cause. And it only needs to be extreme and outrageous conduct may be a legal cause of severe emotional distress, even though it operates in combination with other causes, if extreme and outrageous conduct contributes substantially to producing such severe emotional distress. Contributes. Their call.
Well, let me just, because I think for an intentional infliction of emotional distress, it's a little bit different, at least with respect to the question of outrage. Because, I mean, under Stedman, that says that it's an issue of law. So, I think that's squarely before me here.
Okay. I'm working backwards.
Okay.
Yes, Your Honor. To go to the question of direct, there is nothing in the instruction, standard instruction, or I think you heard admitted in the case law, that says it has to be directed to Beata Kowalski. The claim refers to acting extremely and outrageously that caused her severe emotional distress. Under the hospital's theory, you could have someone take and beat their child in front of them, and it's not directed to the parent, so the parent has no emotional distress. That's not severe and outrageous to the parent. We've heard, and I was here to hear part of this morning, Beata Kowalski heard of everything that was going on. She heard some on the phone. She heard some directly. She witnessed some the first week. This reference to they could have been transferred. It's my understanding that transfer would have required Beata Kowalski to admit, in effect, that she had this disease, that the parent had this disease they were accusing her of, and not that it was CRPS. So, that's not really a get-out-of-jail-free card, if you will. That's just one of the things that the hospital or its employees, and there was a reference to the doctors. It wasn't the doctors. It wasn't just the doctors here, as we know. This Ms. Beatty was a prime actor here. We heard again this morning how she was trying to drive a wedge between the family.
Well, let me ask you the same question I asked Mr. Altenberg. Do you have any case law that discusses the direct versus indirect nature of the conduct and to whom it was directed?
No, Your Honor, but again, the instruction doesn't say anything about that. If the Florida standard jury instructions and this cause of action wanted to say you've got to direct it to the person, they would say that. And what we have here, and again, what about somebody who knows you were, I'm not saying this was happening here, what if you knew somebody was beating your child? You don't see it, you're getting reported, you're hearing about it, you can't do anything about it. Is that not going to inflict emotional distress on the parent? The parent does not have to be the target of what's being done. Now, I think there is evidence here that Beata Kowalski was the target I don't know who she riled up when she first came into the hospital. We've heard talk about she's kind of aggressive. She wanted this treatment for her daughter and so forth. Certainly Ms. Beatty, we have her heavily involved. We have her doing and saying things that are, I would say, outrageous. I think it's a jury's call, ultimately, as to whether they would agree with that. But it certainly meets the threshold standard. You talk about, asking the husband, thought about divorcing your wife, get away from this crazy person. That's being the implication. So again, I don't think there is any case law, and I think we heard that earlier, that says it has to be directed to the person who is the ultimate victim. Although there was plenty we've heard about directed to her, and I think that's part of it. To try to take this and break it down and say, well, this little thing here didn't, this little thing didn't do it. It kind of comes back to the part at the end where we're saying, well, there wasn't medical evidence of distress. She killed herself. She committed suicide. Isn't that sufficient evidence of distress? I don't think you need a medical, somebody to say, well, she went and saw somebody the day before that and told them about this or that concern, or told a neighbor. That's not required. The distress here is obvious. And the hospital's treatment, including the hospital employees like Ms. Beatty, only need to be a factor of that. It does not need to be the whole cause. It just needs to contribute to it. And there's certainly plenty of evidence of that here. In terms of the outrageous conduct, we heard again, things that Mr. Kowalski learned of were being reported back to Mrs. Kowalski. She knew some firsthand of things that were going on because she's on the phone calls. She hears what's going on there. The whole show, if you will, the whole thing being orchestrated to separate her from her child, which I realize happens. Part of that you've ruled on, but part of it you've said is fair game for this jury to consider. Those are things that she was allowed, that if you will, are allowed to act as part of this claim. And keep in mind, this situation when she comes in, even those first few days, she had been to the hospital, the same hospital, with the same diagnosis of CRPS before. Why is it suddenly being changed? Why are they not recognizing that? What's the motivation? I think there's plenty there for the jury to say, there's something else going on here. And again, who Ms. Kowalski irritated or aggravated doesn't really matter at the hospital, because this shouldn't have happened as a result of it. If you have more questions, I'm happy to try to answer them, but I think there's enough here to go to the jury, and that's the question. It's not, that's where they are, we're out here. I understand you on the threshold, but think about these things from the point of view of the parent who's being separated from the child, who's being accused of these things, wrongfully, we would say. Another question for the jury. And who this contributes to her ultimately taking of her life. So the evidence of distress, I would suggest, is obvious. There's no requirement in the case law or in the, more important, in the jury instruction that will be given that requires it to be directed to Mrs. Kowalski as opposed to their daughter. Some of it was directed to her, but.
Okay, is there anything else in your argument? I just want to make sure that there's nothing else.
Yeah, there are, the other facts, Your Honor, that we heard this morning, the dress, she knew about that. She knew about her daughter being deprived of that, being deprived of religious artifacts, the ability to practice a religion, all those different factors. I mean, denying somebody the ability to practice a religion is pretty intentional. I mean, what is, it's a dress that came from the parents, and you're denying the daughter this, I think it was a holiday, a Christmas dress. You're denying her there. I mean, what possible medical purpose is there for that? What possible purpose is there other than you intended to inflict some kind of harm? be it on the daughter and the parents. And there, I would suggest plenty of facts here, but I haven't been here for all of them, so let me ask my trial counsel if there's anything else we need to supplement with.
Two risk management notes that are in evidence are worth mentioning in the context of this argument. The first is Exhibit 2277-248. This is the note the court saw yesterday or the day prior, where in the team meeting within the hospital on November 16, 2016, there was discussion that Maya felt that Johns Hopkins was lying to her about her mother, and that the doctors are lying to her about her parents. In the court's statement, I'm not sure if that's the first time the court had seen that note. The court's statement on seeing that note, when relevancy was challenged by defense counsel, was, that's outrageous. The hospital has a 10-year-old child in their custody. They're supposed to be taking care of her. She mentions that they're lying to her about her mother being in a mental institution, and the hospital does nothing about it. That crosses the threshold. The second note is this, Exhibit 2277-451. This is a note from December 30th, 2016.
But Mr. Whitney, does that go to the intentional infliction of Maya, or does that go to the intentional infliction of Beata?
Both, Your Honor, if I may jump in. You know it's getting back. You know it's getting back to the parents. So I would say both. But, sorry.
Agreed. Well, under the argument, there's nothing in the instruction, there's nothing in the case law that requires direct action. And this is prior to the December 2nd child abuse hearsay of Mr. Kowalski that was testified to. So this would be one of the things that was relayed to Beata Kowalski in early December. Second note is at Trial Exhibit 2277-451, and this is a note from December 30th, 2016, where it's noted that Maya has scratches on her forehead for Dr. Elliott, and then the hospital at that point adopts an extravagant theory that this is a possible trap for Dr. Major to have it appear that there's neglect in the care of Maya, not knowing that she had a lesion on her skin. We've been through the records juxtaposed against the photographs that Mr. Kowalski was taking. For 2 months, 3 months, the hospital refused to document the lesions on Maya. And when it was brought to their attention, they instead adopted this theory that mom is coaching up the daughter in her limited time so that Maya is self-inflicting scratches rather than the obvious thing that's really happening here, which is she has lesions manifesting because her CRPS is getting worse and she's deteriorating in this hospital's care. So both of those notes from the hospital's risk management file point to the outrageousness of the conduct.
But what if Mr. Altenburn is correct that we have to have conduct expressly directed towards Beata?
And we've been through this at some length today, but for purposes of this part of the record, the conduct that was directed towards Beata are the statements made about her, which she learned. That she should get a divorce, that she was crazy and was in a mental institution, that she was putting her daughter in a coma every week. All of these statements were not made directly to Beata because she wasn't allowed in the hospital, but were funneled to Beata through a proxy, which was her child, her 10-year-old child. And then you have, of course, the direct interactions of her with the hospital and the direct interaction of her on these phone calls with Ms. Beatty, where Ms. Beatty interrupts her at every turn, won't let her pray with her daughter, won't let her ask basic questions of her daughter. Those are actions directed that were experienced firsthand by Beata, is the way to say that. So those are my factual insertions. Thank you.
Anything else, Mr. Elliott?
I think not at the moment, Your Honor.
I'm sorry?
I say not at the moment, Your Honor.
Okay, any brief reply, Mr. Altenburn, or? Yeah. Oh, hold on a second.
Almost.
I've got Mr. Anderson who can't seem to help himself here.
That's all right.
As I see it, the court's concern is what did the defendants do directly to Beata that was outrageous? Granted, this is a little bit different. because what you have are telegraph punches. You have, and let's face it, the evidence taken as a whole indicates that there was a desire and plan on the part of Kathy Beatty to separate Maya from Beata, and she so stated. There was a plan by the hospital to force Beata and Maya to change, and Jack, to change their story. I don't think there's any question that there's enough evidence. In fact, we believe it's overwhelming evidence that that was the plan. The next question is, well, what about to Beata? And the facts here are that every single thing that Jack heard, saw, perceived, went to Beata. And so we argue that this was the intent of the hospital. And this is what's so horrible about all this. This was separation of mother from child with knowledge by both and without the ability to combat it. And so what you have here is a plan that is told to the mother that we are going to take away your child and there's nothing you can do about it. There is nothing more outrageous in this society than, that. It is a fundamental, not only right, but it is a fundamental part of the human experience to raise your own child. And in this instance, we have people, and there is so much evidence in the record, it's overwhelming, that want to separate the two. And we're trying actively to separate the two. And that, the important thing, judges, that plan, that desire, was communicated to Beata over an extended period of time. And if you look
but I think to be fair, we need to excise out any contention that because there was reasonable cause for the abuse hotline report, and it was the court that authorized the sheltering. That's not Johns Hopkins, and they're not liable for that.
I understand the court's ruling. And I have excised this out, and you saw that with the testimony of Dr. Richards today. Rather, what we're arguing is outrageous, is that over, and it's not the period of time so much as the sequence of events ramping up the pressure on Beata Kowalski, the directives from risk management going through Beatty, perpetrated by Beatty, communicated over, yes, a period of time, but not a period of time about false imprisonment, a period of time to raise the pressure on Beata by hearing about this, this, and this. And if this doesn't get her, let's take away the Christmas dress. And if this doesn't get her, let's suggest that Jack get a divorce. And if this doesn't get her, let's tell her that I'm going to be her mother. All of these things, the evidence in the record is, were communicated to Beata. And so I asked the court to look at the series of events, not from the time, but from the ramp up, the steady ramp up of pressure on this mother, knowing that her hands were tied until, and this has always been our position here, that they intended some reaction out of Beata that would add to their story or serve as the end point to their story. See, Beata acted criminally and came in and tried to steal her child back, or see, Beata was out in front pounding on the window, or any other outrageous act on the part of Beata that would confirm their theory that Beata was crazy, had Munchausen by proxy, and was just afraid of getting caught. I don't know what the bizarre idea ultimately behind that part is, but I do know that these were doctors, and this was a hospital, and they understood that if you continue to keep the pressure on a mother in this circumstance, that mother is ultimately going to break in some form or fashion. And in this instance, what I think is they were surprised, and then I thought, but they weren't, because afterwards they said they expected it and it had happened before. So to our point, Judge, the real outrageousness of this is the systematic nature of the actions against Beata through this. And everything, every contact that she had and everything she learned reinforced that there was a plan to take her daughter away, and that is outrageous in our society.
Your Honor, if I could I tag team in for just one moment to finish up on?
And this is why I said my precatory comments about this, because I want to be able to get through at least one of these motions before we have to leave today.
Yep.
So I will let you say it, and then I'll go to Mr. Altenburn for a response, and then we're finished.
Mr. Anderson's ramping up. The last ramp up, or maybe the last ramp up, is January 6th when they take the pictures of Maya, and that is relayed to Beata Kowalski, and she commits suicide the next day. That's my understanding. That not, if I've misspoken on that, I'm sorry, but that's my understanding is she learned of it. So
She didn't see the photo, but she was.
I think there's a question of whether there's any evidence of that issue in the record.
All
right. Okay. Anything else before we go to Mr. Alton? Mr. Whitney?
I'm going to just make one comment, and I'll be done. I apologize.
And I really probably need to enforce the one lawyer, one argument type of rule, but since I haven't, go ahead, and then I really do need to move on.
The text messages reflect this plan. The comment in the text messages surrounding the EEG video and this targeting of Beata Kowalski is, I wouldn't put anything past her mother. That's it.
Mr. Altenburn.
I think that would put anything past her mother was Sally Smith, if I recall. But first of all, the notion that we are in a conspiracy to target this, A, conspiracy is not in this lawsuit at this moment in time, but B, I mean, it is speculation upon speculation to do this. The notion that these doctors, in attempting to take care of this child, were that they had some vendetta against the mother is simply not in this evidence, and it's really kind of an insult to the to the hospital. This child came in with reports from the mother and the medical records from Lurie's and Tampa General Hospital indicating that they thought there was a psychological problem going on that was possibly Munchausen's by proxy. That's how this ends up on the front end of this. I think it's important to point out that these two diagnoses aren't all that far apart. We're talking about a situation where a nerve or a muscle or whatever is not in fact damaged, but instead the delivery of the signals from that nerve to the brain are processed improperly in the brain. The CPRS people believe it's this glial cell ops situation, and the people who think that this is a factitious disorder believe that it's done through a psychological process. But nobody's claiming that Maya is faking it that she's making it up. It's that psychologically in her brain, however her brain works, one way or the other, there's something going on that's not real in her legs. It's a diagnosis issue. Maybe the diagnosis was for one or the other is different, but you've heard the testimony from all of the experts that the treatment for these things is physical therapy, occupational therapy, cognitive therapy, and if all that doesn't work as the last resort, you might consider ketamine. So in terms of us having a vendetta against this woman, the truth is we're simply trying to get a treatment package for her daughter that works. It's the court that has separated them from us, and that is just a problem that is very hard for us to deal with. Now, as far as the lesions are concerned, yes, there's a disagreement between the doctors, and you can see it in the medical records as to whether or not we think the little red dots and the little scratches that you've seen are actually things that are consistent with CRPS as compared to something else. That's a medical fight, but that's certainly not something that arises to the level of outrageous conduct. And finally, on the issue of direct or indirect, virtually all intentional torts are things that are done toward a person. The notion that we will have a tort of this sort that is done because of things that are done in the hospital that her husband takes home, that some of which we probably know, but certainly not all of which we know is going home to mother, is simply not enough for this tort. I could say more, but we're going to run out of time. So unless you have more questions, I'm going to move on.
I do, and let me see if I can articulate it. Obviously, the conduct has to be so outrageous.
Yeah.
To me, not giving somebody a Christmas dress might be in bad form, but that by itself isn't
Right.
outrageous. But given the standard I have to apply on direct verdict, which means I have to take, all the facts that are here in the light most favorable to the defense. What about the argument that we see a series of events that arguably are directed to Beata Kowalski, that evidence and intent to maliciously prevent and drive some type of wedge between mom and daughter? And I guess what my question is, am I able to, or should I look at the series of events which singularly might not, like the Christmas dress, might not be itself? Or is a series of events, any one of them by themselves is insufficient, but in combination is sufficient? And then I'll let Mr. Elliott comment on that. Or do I need some sort of one overwhelming direct conduct towards Beata, which is necessary to show outrage?
I don't think that the law requires one overwhelming specific incident. It can be things over a duration, but when you look at these things, as you say, that there are a number of things they complain about, like the dress and rudeness on the phone call and whatnot, that don't really accumulate much in this situation. And to claim that those things were done by the hospital because the hospital had some malicious plan to take this child from the parents. The decision whether the child was going to be taken from the parents was going to be made by a court in February based on evidence about medical child abuse. It had nothing to do with what the hospital was going to do in the interim. I don't see why they would even have thought they should have this kind of conspiracy. But moreover, the things you look at, we put her in an EEG room trying to videotape to see whether her conduct would be consistent or not with CRPS over a 48-hour period. We took photographs because she's beginning to have scratches that look to us like scratches and not like something from a disease. She's going out of the hospital, and we don't want to find out what she looks like when she comes back as to whether she has more scratches coming back than when she went in. Those things may seem, invasive in some fashion, but they're not irrational, and they're not designed as a method to be malicious to anyone in that process. So, by that point in time, there are lawyers everywhere in this thing, and the hospital is just as concerned about this as the family is. And that process in the court is the overwhelming pressure on everyone in this case. So I submit to you that simply when you start with intentional infliction of emotional distress, it is not there. And that certainly when you jump to suicide, a suicide that takes place under these facts when nothing particular happens in the hospital she knows about in the last 72 hours and everything particular happens in the court after 100 days there, this can't be a case where we jump from intentional infliction to a suicide caused by that. There should be a directed verdict on both of those counts.
Mr. Elliott, did you want to respond to the question I asked Mr. Altenberg, and then we'll move on after that?
Yes, Your Honor, I agree. It does not have to be a single incident. This is a series of incidents. It starts, as my colleague said, with the threat to arrest her at the very beginning, and it ramps up and up and up. They take away the toilet, move it from her. All these things, and again, the parents heard about it. The text message after the fact says predicts this was going to be a suicide. It's going to happen. This is a course. It doesn't have to be a conspiracy. They don't have to conspire to do it, but they did it. And it wasn't just the doctors. It was the staff. Thank you.
I'm going to take the directed verdict motion with respect to counts 21A and B under advisement. Mr. Altenberg, your next one, please.
The next would be count 21C, which is the same count for Maya Kowalski.
So for the clerk, the first one was on 21A and B. This one's on 21C. Count 21C.
This count is obviously different because Maya is in the hospital, and there are things that happen direct to her. And as you have noticed, a number of those things may rise to levels of rudeness and the like, but maybe not to extreme and outrageous conduct. The thing I'd like to really emphasize to you is that when the allegations in paragraphs 239 to 240 of the Eighth Amendment complaint are allegations where they go through and say, well, she was battered when she was in the hospital, and she was falsely imprisoned in the EEG room. They go through a list of things that are already the intentional torts that they are alleging elsewhere. Torts that if they prove, are going to get emotional damages. They don't need another tort for this. It's an overlay of that. And so when you take out the things they have alleged in here to make this and the things they claim they have proved here, the things that are left compared to the intentional torts that they have here are not sufficient, I don't believe, to state a claim for intentional infliction of emotional distress. And at a minimum, if this goes to the jury, they need to be instructed that, not only are the damages are not duplicative, I think the damages for the intentional torts they have alleged and this are essentially the same damages. So I don't believe that this count needs to go to the jury. I think it should have a directed verdict.
Assume for the sake of argument that the damages are duplicative. Is this something that the plaintiff would have to elect now, or would they be able to elect later?
I haven't thought about that. I mean, that, obviously on 21A and B, if those two went in, there has to be an election, and the law is on that particular count that it would be an election after the fact. I was frankly envisioning something, if we had to do this, that would just tell them they couldn't duplicate over and over and over again, by the way, in this verdict form. But I know of no law that equates those two in a fashion that would require an election as compared to non-duplication.
Mr. Elliott.
Are you asking about that particular question or
Well,
in general?
I think Mr. Altenburn was finished with his argument with respect to 21C. So your response, and then if you can throw in your comments as to my question.
I would agree that there is no requirement that says you have to, you would get rid of count 21C because it duplicates damages. If there's a duplication, there are ways to deal with that. But there's lots more going on for 21C. You have to keep it in the context that all these things are being done to a 10-year-old girl who's sick, like moving the toilet away from her so she can't get to it. The religious aspects of what we've heard about. So all these things, and they are being done directly to her. So, and she also sees what's going on, with her mother too, but sees or hears. So you have that as well. Again, unless you want to hear more, I think you know the facts, you know what's going on. I mean, there's plenty here in my view.
I'm going to deny the motion with respect to 21C. The light most favorable to the non-moving party here, the plaintiff. The court finds this to be a jury question.
Okay.
And then we can address the potential duplication issue in the jury instructions when we get there.
All right. Next, I'm moving to count 6C, which is a negligent infliction of emotional distress count, both for Mr. Kowalski and a separate claim for his daughter, Maya Kowalski. They have similar issues, and although Maya's is somewhat more complicated. As I'm sure you know that under the traditional Champion versus Gray and Zell line of cases, you have to have, in some fashion, experienced a tort that was committed on a close family member, and that has to have caused you emotional distress, and the emotional distress then has to in turn cause a physical injury. The requirement in Brown is that it be one that's such psychological trauma must cause a demonstrable physical injury such as death, paralysis, muscular impairment, or similar objectively discernible physical impairment before a cause of action may exist. So I've cited to you before in Elliott versus Elliott, the First District found that headaches and diabetes and sleep apnea and stress and insomnia, anxiety, loss of appetite and hair loss, bowel trouble aren't enough.
and I know we've been having this argument.
Yep.
Over and over, and did I actually write on this issue?
You denied a summary judgment based upon what was there as compared to what we have now.
But did I make, in that denial of summary judgment, did I make comments about the Zell case and these other guys? I'm trying to remember.
I don't remember. The one thing I want to tell you about Zell, though, is because it gets misquoted, I think maybe even in a comment to the jury, the standard jury instruction. In Zell, the woman experienced watching her father get blown up by a bomb. She gets severe stomach problems. Those problems get worse and worse. She ends up getting various treatment. She is diagnosed with fibromyalgia and with an orthodontal dysphagia, which is a problem in her esophagus. She gets a medical doctor that says all of this is caused by the stress. In his medical opinion, he says, additionally, in my opinion, within a reasonable degree of medical probability, she has suffered from insomnia and anxiety with a depressed mood. That gets picked up as, oh, that's enough for the cause of action. But that was the additional part that follows things that were enough for medical diagnoses of real physical injury. So the Zell gets taken out of context, and the language in Brown versus Cadillac has never been receded from by the Florida Supreme Court, nor has anyone criticized the language in Elliott versus Elliott. What we have here is he says when he first got on the stand that he had anger, loss of sleep, diarrhea, nausea, and trouble digesting food. That's not enough. He has tired and a little nausea was what he said the second time on the stand. And then he added that he had sometime a couple years afterwards about an eczema that he apparently got treatment for. But the eczema, unlike in Zell, there's no medical doctor that says that there was treatment, there's no bills, and there's no medical opinion that eczema was somehow caused by this particular incident a couple of years earlier. We've heard in the testimony, I think eczema kind of runs in this family to begin with. So I don't think the eczema is enough. And then the last thing we heard was Dr. Brewerton, who evaluated the family for PTSD. And he said, and I was very careful listening to this, based on the events from October 2015 through January of 2016, he thought that Mr. Kowalski had PTSD. And he tried to make that an organic disease by saying that there's evidence that sometimes that there's a loss of brain tissue in the hippocampus section of the brain. Now, he didn't do any tests on this, on Mr. Kowalski to say there'd been brain damage here. And frankly, there's no medical bills and there's been no treatment whatsoever to this point in time for PTSD. So my position is that from viewing the things that he saw in the hospital concerning his daughter, there are the claim for negligent infliction. Not only is this not tied to that, but none of this is enough to reach the level where this goes to the jury as the physical injury that's required.
And just, I did write on the Champion and Zell. It's the DIN 3133 docket identification number 3133, which is June 26, 2023 order. And basically I agreed with Justice Cantero's decision in Willis that was joined by Justices Well and Bell about the impact rule and its continued viability. So,
Right.
Yeah. I was going to say, I remember writing it.
You did right, but I wasn't going to tell you what you did right. Jumping quickly to Maya, by the way, she has the first threshold that what's the underlying negligent act she viewed. There's no negligent claim for the mother. The jury instructions they proposed are the negligent treatment of the parents in the hospital, but there's no jury that has made or will make a finding on that. So I don't think she has the predicate to begin with. But then I listened very carefully to her testimony sitting here, and she talks about all the problems she's had with the CPRS, but I didn't hear a single thing where she said she went to the doctor or had particular problems because she had witnessed something related to her parents. Not even the suicide of her mother is something that she claimed caused something here. There's just simply no evidence that she has had the kind of demonstrable physical injury that is required for this. So I don't think either one of these counts have been proven. We get a directed verdict on both of these.
Thank you, Mr. Altenburn. Mr. Elliott.
Your Honor, admittedly, I was not here, but I understand there's testimony from Mr. Kowalski that testifying to nausea, insomnia, diarrhea, headaches, vomiting, certainly those are physical manifestations.
And I think there's case law that list out those specific ailments, and talking about probably is not enough.
Some of them, I don't know about vomiting is a pretty well, that's a little different than headache. Let me go on to Maya, and I'll come back and let my more knowledgeable factual counsel help with that. But on Maya's, and I know we'll be talking jury instructions with you in a bit, but the case law refers to a person hearing. You don't just have to see it. If you hear something going on that causes emotional distress that's being done to someone else, and you hear it and it causes you the emotional distress, that is sufficient. And she overhears her parents being threatened to be jailed during the first week. She overhears conversations with her mother where she's being accused, including being accused of things and so forth. So there's plenty going on there. It's not like you have to witness a physical thing happening. Mr. Kowalski certainly witnessed plenty. I mean, he had to clean up after his daughter when they moved they fix it so she can't get to the bathroom. So, he clearly has that. And I don't think we heard that argument, but hearing it is sufficient for Maya's situation. Oh, do you want to?
Well, this is the plaintiff's opportunity to say whatever they want to say as it relates to this motion.
He has dysphagia. He goes long periods of time without being able to swallow.
As far as physical manifestations, I understand Maya's experts have testified that these things have had an impact on her, physical impact on her, not getting better or getting worse. And I understand Mr. Kowalski also has dysphagia that he's testified to, swallowing difficulty and so forth. So again, that's another, I would say, physical ailment that is beyond simply a headache.
Mr. Anderson, go for it.
You're a very patient judge. I thought that Dr. Brewerton went through in detail that the PTSD that they both suffered actually goes in and organically restructures the brain. That is a physical injury. Now, the cause is the PTSD, but I think he testified that the latest data on that indicates that the brain itself goes through a process and rewires itself to keep keep these physiological reactions going. That rewiring is a physiological change, and that occurred with both Maya and with Jack. And Dr. Brewerton was very, very clear about that, and that this was related to the what happened to them. So I'd ask the court to take that into account. We now know more about PTSD and the fact that it has a physiological component. It hasn't been addressed by the case law yet, but that's the latest science.
Anything else, Mr. Elliott?
Not that I can think of right now, Your Honor.
And Mr. Altenburn, last rebuttal word.
Very, very briefly, again, this is an account for having viewed a negligent act. They've tried to bring in other intentional acts. That's never really been alleged. But even if it were alleged, again, the testimony from the experts has been about this whole range of things that goes from A to Z, and not the things that happen just in the hospital. And B, that while the theory is that it causes this restructuring in the brain, there's absolutely no evidence that any doctor has ever found that whatsoever in these two people. They haven't even really been treated for this disease in what has it been, 6 years since this event took place. So there is no evidence in this case to present to the jury that there's a physical impairment that's been diagnosed by our doctor or treated, and there is not enough to go to a jury.
Yeah, I'm going to take the directed verdict motion with respect to count 6C under advisement. And Madam Court Reporter, I'm going to want the entirety of the arguments on directed verdict starting at 3 o'clock today till the time we finish. I'm going to want a transcript of them. When I say as soon as possible, hopefully tomorrow or maybe Wednesday, if possible. Okay, Mr. Altenburn, you have the floor for the next motion.
Yeah, I'm jumping to count 18, which is fraudulent billing. Technically, the count is alleged for all plaintiffs, but I think maybe they really think it's only a count for Mr. Kowalski at this point in time. I don't know that it makes really that much difference. This is a count for intentional fraud. It's not a count for negligent misrepresentation or anything else. So they are alleging right out of the standard jury instructions that the issues for you to decide are whether John Hopkins made a false statement concerning a material fact in the bills to the Kowalskis and their insurance companies, and whether John Hopkins knew the statement was false when it made it, whether John Hopkins intended that another would rely upon the false statement, and whether they relied, and whether either the Kowalskis or the insurance company relied on the false statement. And I guess we didn't stipulate on detriment, so whether that caused a detriment to these people. So the evidence you've heard, let's start with the basics. Nobody from the billing department at John Hopkins has been called. The bills have just been put into evidence with a number on it along with a list of other things. And no one from Aetna has been called to say that they thought there was any problem with these billings the way they were done. The only person who testified about them until this morning was Mr. Kowalski, and Mr. Kowalski went through a list of bills from Exhibit 2017, and he would show you, yes, indeed, that this bill was sent to the insurance company. And so, for example, 17,739 was sent to them with a $90,800 first offer, I guess, from the hospital, and the insurance company paid $50,853. And his theory is that, I guess, we didn't do work for CRPS for them in the hospital. Well, first of all, he doesn't know what was billed for that amount, and he doesn't know whether it's the $40,000 that was taken off that bill, for example. But secondly, it's undisputed that this child was in a hospital room, in a hospital bed for roughly 100 days, and that this child received occupational therapy, physical therapy, cognitive therapy, and things that, without regard to whether this was CRPS or factitious disorder, that treatment was the same for both of them in the hospital. And even their experts recognize that is recognized treatment. They believe that we should have gone on and used ketamine, but they recognize those treatments. So the notion that someone reviewed that bill at John Hopkins and thought that that was a material fact that they were lying about to the insurance company, and that the insurance company relied upon that to pay an amount they never would have paid, or that I mean, the evidence is simply not there. They've not put on the people that they would need to present that. And, then, to their detriment, the only thing they've discussed is a lien, which if there's a verdict in the way it is, they can argue all of that to you at the end of this case, just like they do in every other case to get it resolved there. Their other thing is the deductible. They admit it's a deductible for the year. They have no idea what that deductible was used for, and this girl went through a litany of things that year. So there really is no proof of fraudulent billing that can go to the jury in this case.
And let me hear from the plaintiffs, and let me first ask about, is there any evidence that the personal representative of Beata's estate or Jack Kowalski as Maya's parent has suffered any damages? And then we can talk separately about whether Jack Kowalski individually has suffered damages. But is there any evidence on the estate itself being damaged because of the bills?
Well, someone would still owe the bills, Your Honor. They haven't all been paid. Mr. Kowalski, I believe, testified he paid.
Right, but I don't recall hearing evidence that the estate owed any bills, and I don't recall hearing any evidence that Maya Kowalski owed the bill.
On Maya, I would agree.
Because right now, count 18, I have 3 different plaintiffs bringing the same count, and I'm beginning to think, I agree with Mr. Altenburn, that it probably really, if it exists, is really only Jack Kowalski individually and not the other 2.
Your Honor, we had this discussion a while back about the liens, and we put that into evidence, a little controversy about it. But wouldn't the estate be responsible for some of those liens, as well as the PR? I mean, as well as Jack Kowalski as the parent and guardian of Maya.
Was there a claim made in the estate by the hospital? I mean, can legally
These aren't bills for Beata. These are bills for Maya.
Yeah, they were bills for Maya. So
and Beata was the parent.
The parent.
Right.
And so was there ever a claim made in Beata's estate for payment of bills? And I don't think there was any testimony to that effect.
I don't think there was either, Judge.
Well, assume that to be true, then if the estate is not legally liable for any bills, then how can it have a claim?
Well, I guess our point is yet, but depending on the outcome of the case, there may well be a claim. And again, we get into the same argument we had before, which is the contingent nature of these liens. And so they can be enforced against either parent, really. So we won't know on that until really it's a chicken or the egg thing.
Well, when it comes to claims in the estate, there's a bar date. And I would submit we are well beyond the bar date. Even if the hospital was not notified of Beata's death, which obviously doesn't seem to make sense here, but even if we were to assume that, we're much beyond the bar date. So I don't think anyone can, unless someone made a claim in the estate, I don't think the estate would ever owe any money relative to the bills at this point. And Mr. Alligator, am I
I would say let's talk about Jack.
We understand the court's position.
Yeah, let's talk about Jack. Your Honor, there's the big picture, I think, is you've got the hospital telling these parents you shouldn't have CRPS, effectively. Doing more than telling, and we've already been through some of that. And at the same time, they're billing the insurance company, I don't know how many hundreds of entries, but apparently for CRPS in the billing codes. And I understand there's an Exhibit 2438, Aetna messages, that Beata had with Aetna. So you've got, you've got a risk management notes, about the lesions not being complex regional. You've got all this stuff going on that says it's not this, and then you're billing and saying it is. That seems like fraud. That seems like, why are you telling the insurance company this? Maybe there was a higher rate. That's not, I don't think the plaintiffs have to explain why they did what they did. You have that taking place. You have a false statement of material fact. Representatives' knowledge that the representation is false. Well, they're telling on the one hand, they're saying it's not this and they're billing for it. Intention, representation, induce another to act on it. Well, why do you send bills? You send bills to get paid. They clearly intended the parents and Aetna to rely on it. And you have consequent injury by the person acting in reliance on it. Some of these bills were paid. Mr. Kowalski's paid. I understand testified he paid toward one of the bills. There's a big chunk of bills still out there. So I think you have all four of those elements here.
Quick response, was there a burden first to prove it was a material fact? Material fact is a fact that makes a difference in the billing. And the only way you do that is putting on billing experts, one side or the other, to explain how these things are billed under the complex Medicare system that we use for billing these days. There's no evidence that this is material. There's no evidence that John Hopkins was intentionally putting something on a bill to defraud them or the insurance company. And without regard to the damage numbers and the like, the front end of this is the problem. They haven't put on the witnesses that they need to do this. I mean, if we have to, we got to put hours of people on the stand from the billing department to explain why this is done in the normal fashion. But we shouldn't have to do that because they haven't come forward with anything to prove that there's a material misrepresentation and that we knew it was false and that we sent it out relying on people to do something improperly.
Madam Clerk, so the court minutes are clear. There's 3 different plaintiffs in count 18. So as it relates to count 18, where the plaintiff is the personal representative of Beata's estate, I'm going to grant the motion. There's no evidence that the estate is responsible for these bills. Therefore, there would be no damage to the estate. And therefore, the count 18 as it relates to the personal representative of the estate is out. With respect to the claim by Jack Kowalski as the parent of Maya Kowalski under count 18, same result. I'm going to grant the directed verdict motion because there's been no evidence that Maya is legally responsible for those bills. With respect to count 18 as it relates to Jack Kowalski in his individual capacity, I'm going to take that motion under advisement. But Mr. Altenburn, have your team call those people towards the end because I'm pretty much in your camp on this. I want to look at a couple of things, but I think count 18 is not going to survive. So I would put that evidence in later and give me a chance to
The next count
go
is
through that.
count 20, which is the fraudulent concealment of the videotape.
Your Honor, can I make one additional point on that previous, if you're going to continue considering it?
Sure.
The Aetna messages at 2438, there's been this issue as to allocation amongst the various diagnoses. I would only ask the court to take a look at those messages when Beata Kowalski asked that direct question, what is this billed for? Aetna does not come back with a list of 4 or 15 different diagnoses. They tell her one, complex regional pain syndrome. That's what those bills were for, according to Aetna in their own words.
Well, what exhibit number are those again?
2438.
2438. Okay, thank you. So we're now going on to the next motion, and we're on count 20.
Yes. And this is a fraudulent concealment of the videotape. I'd emphasize that this is not a count for making the tape as a violation of privacy. And in the allegations in paragraphs 210 to 213 of the 8th Amendment complaint are allegations that we knew it contained exculpatory evidence and that it would be useful in a DCF proceeding and that we had a duty, therefore, to disclose it to them. And that because of that, they had to go out and hire psychiatric and renowned medical experts in an attempt to prove information that JHAC already had on this videotape. Now, for fraudulent concealment, you have to prove that John Hopkins concealed or failed to disclose one or more material facts by not disclosing the videotape. And by the way, the parties are pretty well agreed on these elements. So they're from the tobacco industry has made us lots of good jury instructions on this. And whether we knew the fact should be disclosed, and whether we knew its concealment or failure to disclose the material fact would induce Mr. Kowalski or Beata Kowalski to act or refrain from acting, and whether we had a duty to do this, and whether they detrimentally relied upon that information in these circumstances. Now, to be clear, they didn't know we made the video, and they didn't know about it until it was delivered to their lawyer on, I believe it's the 17th of November, about 30 days after it was made. But the plaintiffs, first, they haven't even put this video in to see what is on it. Other than
I think the video's in. I know there's
two little segments are in, not the whole thing. I don't
4
think.
segments, right?
4 segments. Okay, we got 2 minutes of 48 hours in evidence, and they show various things that we can fight about what it is they mean, but we don't have the whole thing in. But nevertheless, what they really don't have is that evidence from JHAC that anybody in that 30 days reviewed it and said, oh my gosh, there's evidence that is exculpatory. We have to disclose that. There's no evidence that anybody did that or came to that conclusion. And as a result, it should end there. But even if we did that, they have to show that they did something that was detrimental to them. Now, we know that they hired Dr. Duncan, but that was because that was ordered by the Shelter Court on October 14th at the hearing. They couldn't visit their daughter until those things were done. And I'm not exactly sure when they were done from when Dr. Duncan was on the stand, but my impression was that they were done sometime in early November. There's nothing saying that they hired her to have exculpatory evidence at trial from that point in time. They didn't hire Chopra as an expert until well later than this. So the question is, who got on the stand and said that there were things that were done in the 30 days after November 17th, or even from November 17th to the end of the case, things they would have done in that first 30, either they would have done in the first 30 days or wouldn't have done in the first 30 days if only they had known about the exculpatory evidence that is on this video. And that evidence is simply not here in the record. So without regard to whether the plaintiff is one or all three of these plaintiffs, there's no evidence that there was fraudulent concealment of that videotape.
I think this one has only brought Jack in his individual capacity, and Jack as parent of Maya Kowalski.
Okay.
At least that's what my notes have.
Okay. So often it says plaintiffs, and I get worried.
Mr. Elliott.
Thank you, Your Honor. I'm sure I'm going to need some factual help on this one too, but let's start with the elements. They had a duty to disclose this. Under the Patient's Bill of Rights, it wasn't, I mean, there was no as I understand it, there was no notation made in the medical record of this video. So hard to see how they were doing it for a valid medical reason. They wait until after the November hearing to disclose it. They wait 30 days to disclose it. So they can argue about what's exculpatory or what's not, but they concealed it. They kept it from the parents until after that time. And I think Dr. Newberg and Dr. Corcoran both testified to the need to have disclosed this type of thing. Okay, we talked about the medical record. Exhibit 2116, I believe, is that document. At one level, it's a little odd to think about how you say you rely on something that was concealed from you so you didn't know about it. But so I think we have to look at what things would have been different. You know, if they'd have had this video, they could have used it. You would like to think that the hospital that is treating your daughter, if they had something that helped with the situation, with the true situation, the true facts, they would bring it forward and give it to you. And if the DCF proceeding had really been a search for the truth about what was going on here, that you would have had that evidence. They could always give it to you and say, we don't think it's exculpatory, but they should have given it to them. So their parents were entitled to rely on saying, well, if they'd have had something, they're supposed to be taken care of. They're supposed to have our best interests in mind. That, I think, is reliance right there. I think that's our short response for now, Your Honor. If there's anything else you want me to cover in more detail, I'll be glad to try.
Well, what are you contending the elements of fraudulent concealment? Do you have a case?
Yeah, they're actually, I think let's see, Butler versus Usen, I think. Is that the one? Let's see. I think Mr. Altenburn is correct that I think there's a standard jury instruction on that, and I think we don't really have much disagreement over that. So I can
It comes
reach for
like
that.
straight out of a tobacco case is where it comes from. And somewhere in the jury instructions, there'll be a cite to that tobacco case, but I don't have it in front of me.
While he's looking, may I make a few points?
Yes.
Mr. Elliott referenced the patient Bill of Rights. That's in Exhibit 2045-024, and it sets forth that you or your designee have the right to, and then under 15, get information from your doctor or provider about your diagnosis, your test results, and outcomes of care. And that's important because Johns Hopkins has taken a position throughout this case that this video was for purposes of medical treatment. And so under the Patient Bill of Rights of Johns Hopkins All-Children's Hospital, if that's to be believed, Maya and her parents had the right to be informed about the test results and the outcomes of care, about what was revealed, what were the results, what was the interpretation of this EEG video, and that never happened. You also have the 2 risk management notes.
What are the damages if under that theory that if this was a medical test and then it wasn't told what the results were, what are the damages?
The damages are, it's a bit difficult to say conclusively what would have happened if. We can't know that. But we do know that there was a dependency hearing on November 8th and November 10th. And the parents and their lawyers did not have benefit of this video evidence to go show the court. Whether or not she manifested behavior that was consistent with complex regional pain syndrome or not, in fact, the justification in the risk management notes was that they'd be able to see her walking on her own when no one was there. And that's in 2 different risk management notes and OK from risk. So the damages really are, we've heard several times from the defense here, we can't get into the dependency proceeding, and the way for this family to proceed was to bring this to the court. Well, if the video is concealed from them, how can they bring it to the court and get the relief they want, which is, if there's a shelter review hearing on November 8th and November 10th, and the judge sees that Maya is acting in a way completely consistent with her complex regional pain syndrome, it'd be over. The damage is everything from November 8th, November 10th onwards, and even if that ends at November 17th, that Maya remains in that hospital being mistreated, et cetera, that's the damage.
And, Your Honor, it's an intentional tort, so I would think nominal damages would be something we would be entitled to in any event. I believe the standard jury instruction is 409.7 for the fraudulent misrepresentation.
And Mr. Altenberg, any response?
Yeah, first of all, the Bill of Rights is provided because there's a statute that requires the Bill of Rights to be provided. And that statute doesn't create a private cause of action. It doesn't, it creates a penalty by the state, and that is it. And so the Bill of Rights has been used here, and I think Mr. Elliott and I have agreed there can be evidence for some other standards, but the notion that we had a duty to disclose under that, A, is not in this complaint, in this count, and B, I don't really think that's legally accurate. But nevertheless, what they're alleging is that it had exculpatory things that would have changed the outcome of the case. Well, they didn't put in the transcripts, so I'll be happy to let you read those transcripts if you want to, but that evidence was going to be used at a trial in February that never took place. And they had it long before that. Their allegations in paragraph 213 is that in reliance on this, they were forced to seek out psychiatric and other renowned medical experts in an attempt to prove this information that we already had. The information they've given you that we already had is 40 seconds of stuff that I'm not quite sure what it proves or disproves, that people are moving and handling this child who's supposed to be in severe pain, and she's not seeming to respond like she's in pain. But be that as it may, there's no evidence that they hired anybody because they didn't have this tape. There's no evidence, frankly, that in the next 30, 40 days after they had this tape that they hired anybody for the trial where this was going to be the issue. And so they have not proven that. And the notion is that we had a duty to disclose this because it had exculpatory things and we knew it was there. Again, there's no proof that anybody from the hospital had viewed this thing in that 30-day period to evaluate it either as proof in a medical abuse case or even for diagnosis for that matter. They haven't put on any of that evidence.
Court's going to take the directed verdict motion with respect to count 20 under advisement. What's the next one, Mr. Alderman?
The next one is medical malpractice. It will be shorter, I hope, in some ways, although the part as to Sally Smith may not. Plaintiffs have presented this medical malpractice case in a very unusual manner. They put no testimony from the primary treating physician. The Dr. Hanna treated this child for 6 months or more and sat out in the hall, but he never ever came in here and spoke a word. So we know nothing other than what is in his records. As far as our treatment is concerned, they didn't put on a single doctor to testify about anything. They put in thousands of pages of records. Those records were used by their experts to review the way experts are allowed to do to render their opinions. So right now, if the jury went out the door, they'd have expert opinions and a big pile of paper. Now, first of all, by the way, that means you can't deny a motion for directed verdict unless you go read it, which you're not going to do. So at least this one has to be deferred, right? But more importantly...
You're assuming I haven't already looked at it.
Yes. Well, I wouldn't have if I were you. But at any rate...
Maybe that's the difference between an appellate judge and
a
trial judge.
That could be. But the problem here is that may be sufficient in a case where you're talking about a sponge left in a body or an x-ray that hasn't been read. But we have a case that's about a complex regional pain syndrome that is a relatively new concept in medicine. It's complicated. There was fights about its diagnosis. And then more importantly, whether we should use a ketamine dosage that the experts aren't coming in here and say, well, that Boston's Children's Hospital does this and Nemours does this and everybody else does this. There's a guy in Mexico that does some of it, and there's a couple offices around here that do this, but the notion that this is generally accepted treatment by doctors, that's nowhere in this record. So my position is, and I'm going to tell you right now, there's no case law that says this, that you should not be able to just throw in 5,000 pages of medical records and put on your experts and tell the jury to go out and figure this out. That's not enough to prove a case. Beyond that, I want to talk about Sally Smith. And I think I might have had a bit of an epiphany Friday afternoon after listening to our discussions on that. And I think that the plaintiffs are conflating the concept of an apparent agent with something that I would call a gratuitous advisor for a treatment team. And this confusion is very likely to create prejudicial error in this case unless we can straighten this out. And the proper way to do this is to DV the sub-issue of whether she is an apparent agent. The case law, not just for medicine, but for a broad range of torts and contract law for that matter, is very, very clear that an apparent agent is if the principal acts or by words or acts holds a person out to be his agent, and the plaintiff relies on that representation in dealing with the presumed agent, and the plaintiff changes his or her position in reliance on the existence of that principal or agency relationship, that then there is a claim. In a non-medical situation, for example, merely being a franchisee of Burger King and having a Burger King sign, that doesn't cut it. But if I'm a yard maintenance company and I have an independent contractor and I give him a big sign to put on the side of his truck that says Altenburns Yards Business, and I give him a cap that says Altenburns Yard Business, and he goes to someone and says, I want to be your yard man, and they say, okay, and he's out there mowing the yard and he runs over their child. He's an apparent agent for them because they relied on him to be one of the guys from Altenburns Yard Service. And I'm going to be liable for him because I held him out by doing all those things to that person. Now, oddly enough, one of the reasons I've never been a big fan of this particular doctrine is the person going down the street, when the yard man runs over a big rock and the rock throws and knocks their eye out, he's not an apparent agent for that person because they didn't do anything in reliance on the fact that he had an Altenburn hat on his head. And so it's a rather weird document. In the medical setting, we started using this mostly because hospitals started taking things inside the hospital and spinning them off to independent contractors. So the emergency room, the MRI unit, the X-ray unit, some other forms of testing groups suddenly all become some other group that's working inside the hospital. They sure look like they're part of the hospital. No one has a sense of they're not part of the hospital. And so when you go to the hospital, you rely upon the fact that the people inside there work for the hospital. And that's the Rosler line of cases. Again, I don't think that's the best solution, but that's the solution, and the legislature's never changed it since I said it was a bad idea. But what we have here is something that's different because Dr. Smith's not running a unit of any sort inside this hospital. She happens to have staff privileges at the hospital, and she's also the head of the CPT team that has a subcontract or a contract, I guess, with DCF. And so what we know is that when this child first arrives and the people in the emergency room or pediatric intensive care hear this story, they're concerned mostly about whether they have to report. They call the person they know is an expert in medical child abuse, which is Sally Smith. She's not an employee of the hospital, but she has staff privileges there, and they know what her other job is. And she gives them some advice. And the Kowalskis know absolutely nothing about that, and they didn't do anything to rely upon it. But that advice was given. And then a while later, after the report to DCF has been made, Sally Smith has been assigned to be the CPT investigator on this, and she apparently shows up at the hospital, and I gather these interviews with Beata and maybe Jack, at least one of them occurs in the hospital. And she's got the evidence is she has a white coat on that says Johns Hopkins, and she has a tag on that says Johns Hopkins. I can live with that. But what did they do in reliance upon the fact that she has the white coat and that? They talked to a CPT investigator. And from what she heard, but more importantly from all the medical records that she quickly gathered up, she decided it was time to convince the lawyer at DCF to file a shelter proceeding. And that happened. Now, I got to tell you that if they had realized that she was from the CPT team that day and said, we're not going to talk to you, I don't think anything was going to go one bit better for them. And they certainly haven't proven that they wouldn't have gone to a shelter hearing if they hadn't talked to this person at that point in time. That's a whole different subject. So there was no treatment done in reliance upon her being a member of the employees at Johns Hopkins. Now, from that Friday at the shelter hearing where she appears as the CPT person, at the very latest at that point in time, they know full well that she's not an employee of the hospital. After that point in time, what's bothered you, and I understand why it bothers you, is that the team has collaborated somewhat with her. And when she finishes her report that she files with the court, which is like a 50-page report of all the medical things that this child has gone through in the 2 years before, that's put with the medical records. I guess not in the medical records, but somehow physically with those records. It's a report that's given to the state, but they have that. Now, the Kowalskis did nothing in reliance upon that. Their allegations have been, well, she recommended that a port be removed. I think if you look at the thousands of pages of medical records, you'll see that doctors at the hospital did the same thing. They advised Beata Kowalski that that should be done, and she said no, and they didn't do it. So even though that advice was given, nothing was done in reliance upon that. So what I'm trying to explain to you is that if you're looking at this properly, she's more like a gratuitous advisor to this team. And it's not so much whether or not she is negligent, but if that team itself relies on somebody and what they're relying upon is negligent material, and they should know it's negligent material, they probably breached a standard of care. And so the fact that they were considering this stuff, especially if it was bad stuff, and that an expert would say they shouldn't have relied upon, I'm not disagreeing that that's admissible. It just doesn't have a single thing to do with a parent agency. It's a whole different question. And the reason there's not just this is not a one-off in this case, because lots of hospitals, in addition to All Children's Hospital, have lots of people who have staff privileges at their hospital. People who work for these hospitals call them up for a bit of free advice when they're trying to figure out what to do as hospitalists and the like. If the staff privilege people, who right now the hospital has no liability for, and those people are not on the hook if they answer the phone, if all of a sudden they become apparent agents because they have staff privileges and they're contacted by the hospital, even though the patients knew nothing about it and didn't rely on it, there's going to be a lot less communication from staff privileged doctors. So there's no reason to go this far when there's a proper analysis to this, just looking at our own doctors and whether they should or shouldn't have taken that into advice and whether that affected their diagnosis or, more importantly, their treatment while she was in the hospital. That's a whole different subject. So I'm moving for a directed verdict as to a parent agency on her because I do not believe that under the law of Florida that has been proven.
Are you complete with your argument?
Yes.
Mr. Allen.
Thank you.
Thank you, Your Honor. To start with the medical malpractice, we don't just have thousands of pages of records. We have Dr. Duncan testifying that this was improper psychological care. We have Dr. Chopra testifying that they breached the standard of care in failing to properly treat Maya's complex regional pain syndrome. We have Dr. Newberger testifying to multiple pediatric physicians breaching the standard of care. So there's plenty of direct testimony that Johns Hopkins committed medical malpractice. You don't have to wade through 5,000 pages of records to figure that out. It's right in the transcript from what I understand. Now, turning to the agency issue, I guess if we're talking about pleadings, I'd say I don't think gratuitous advisor was pled as a defense, since we seem to be big on pleadings, but I just, it's kind of like you can call it what you want, but she's really an agent. A parent agent, at least, maybe an actual agent from what we see evolving. She is, in terms of what
judgment out the actual agent.
I know you did, but we're hearing more stuff now, and I don't know that we have to go there because I think we have the apparent agent is clear from what we have. She's escorted into the room, introduced to them, not as somebody from outside, not making no distinction that she's outside the hospital or anything. They do talk to her. You know, I hear the argument today, well, you know, the Kowalskis didn't prove something would have been different if they'd have known the truth. Well, you know, they haven't said, well, the same things would have happened if the Kowalskis hadn't talked with them. That would be something that, you know, that would be a hospital burden. But we have Dr. Newberg again testifying that Jack and Beata Kowalski had reason to believe she was an agent and had authority to act, given her routine presence at the hospital, all the different things she was involved in, including coming in, presenting the way she did with insignia and so forth on. In terms of, and I understand Mr. Kowalski testified that he relied on her presentation. In terms of whether you even have to have reliance, the Rossler case that we're referring to, in which Mr. Altenburn did have a concurring opinion, say maybe we ought to just, move away from this, charade of people. A lot of times hospitals today want to act like they're just a flea market. They're just renting booths to people to come in and do things, okay? And they're, we don't know what's going on over there when doctor's doing something, but they're not a flea market. And I would endorse, if somebody ever got around to writing it, the view he expressed in that concurring opinion. But the more important thing for our purposes, I think, is the majority opinion. And I don't think we have to go there because I think there's plenty of reliance, but the majority opinion, if you look at page 1161 in footnote 3, it says that when you show up at the hospital, your reliance is presumed because you have shown up there. That's a second district opinion from 2003. So we think we've got reliance and it's presumed. Now, I'm sure I don't know all the facts. Somebody.
My point on this is, in terms of detrimental reliance, I'd ask the court to consider the testimony of Dr. Kirkpatrick and testimony of Jack Kowalski regarding the fact that Beata and Jack were on guard about misdiagnosis and problems with getting CRPS properly diagnosed. They were on guard about this. They walk in, there's a doctor there. Unbeknownst to them and to Maya, she is actually a prosecutor. You can call her whatever you want, but behind the scenes, her goal is a prosecutor. However, she's wearing a lab coat. It has the Johns Hopkins sign on it, according to the testimony. And she comes in and she doesn't identify herself. And then she takes down the history, which is in the record, but the history is designed to prosecute the Kowalskis. And the detrimental reliance is this. But for her being in there and presenting herself as though, in the hospital presenting her as though she were a doctor, they would have, if they had known she was who she really was, they'd have turned around and walked right out. If they relied on the fact that she was a physician with the hospital who was there to try to assist them and help with the child, but instead she was a secret prosecutor, I submit to the court that had they known on that first time, that first day, they would have turned around and walked straight out of that hospital and none of this would have happened. Had they known Sally Smith was who she actually was, instead of believing, based on the hospital's action, that she was just another doctor there to help. That's my point on it.
Anything further, Mr. Elegate, before I let Mr. Altenburn have any brief rebuttal?
Nothing further.
Anything further, Mr. Altenburn?
I don't disagree that in context of a hospital, if it's a radiology department, the presumption kicks in. That's what that case was about. That presumption hasn't been extended to people who are staff privileges who were called in that fashion. The standard rules apply on that. And what we're talking about is whether she is part of the team for medical negligence. And I mean, the law is just very clear on that. As to what would have happened in the DCF proceeding if they had blown her off, that's a lot of speculation, but I mean, her 50-page report on this wasn't based on what they told her. It's what she went and found out with subpoenas to get medical records from everywhere else. So I think that this is an issue that's chasing itself, looking for some relevance somewhere that it just doesn't really have in the suit, and ends up allowing them to make Dr. Sally Smith the evil person, yet another one of our bad people, and that should not be taking place when this case goes to the jury.
The court has before it actually two separate motions for directed verdict. The first is the general directed verdict motion with respect to medical malpractice. The court finds that the plaintiffs have presented a prima facie case
and it's going to be able to go to the jury, so the court will deny the motion with respect to medical malpractice. With respect to the question of apparent agency with respect to Dr. Sally Smith, again, the court finds that there's a prima facie case here, and it's now a jury question on the question of apparent agency. So I'll deny that motion as well. What's next, Mr. Altenberg?
And I'm going to try to do this very brief. Count 14 is the negligent training count. It's hard for me to make a motion for directed verdict because the way it stands right now, we haven't settled on what the jury instruction is, whether it's a medical malpractice standard of care, which I heard opinions this morning within a reasonable medical probability. Right now, the standard instruction given to me is different than that. I think we need to argue about what this claim is before I can, with jury instructions, before I can move for a directed verdict on that. But what I can move for a directed verdict on now is that it is a claim for negligence. And their theory, by the way, is that they can get direct monetary damages here for negligent training without proving that anybody did anything negligent underneath this. And that just doesn't fly. But more importantly, I listened carefully to Dr. Corcoran, who's been their primary expert on this. And if we're looking just at negligent training, there's no physical injury caused by impact resulting from the training. Now, admittedly, there may be from doctors who committed medical malpractice because they didn't receive adequate training in medical school. I don't think the statute they're relying upon actually requires the hospital to provide more than an hour's worth of training on risk management issues. But one way or the other, the claims here are really claims that aren't separate standalone claims for negligence. This is simply something you can use if you can't prove medical negligence. That I gave you a memo, a motion that we never managed to hear this part of on critical jury instruction issues. It's at, I think, DIN 3396, if I can read my handwriting. But the case law on these training issues is normally in federal cases where the person isn't deemed to be an employee, or in cases where they're otherwise outside the scope and course. It's not in this situation. So in the absence of some evidence from Dr. Corcoran and the like that not only did they breach the standard of care, but that as a result of that, there was some kind of physical injury from impact on a negligence claim, they don't have a claim here on this.
Mr. Elliott.
Your Honor, I think we have not gotten together on this. I think our predecessor had some conversations, but I agree, this is really part of medical malpractice. I mean, that's how you get to part of what happened here. But there is, I understand, testimony from Dr. Brewerton, Henschke, Duncan, and others that the training was lacking here. That some of these things may have been taking place because the doctors, they didn't know how to recognize CRPS. That rolls over into the medical malpractice claim, but that, and perhaps it should be treated as a subpart of that, but that's still a claim, and it's still evidence that should come in. So, and again, we're still working on the jury instructions, but that's one that I can easily see how that could be rolled in.
Anything else, Mr. Altenberg?
No, I think that speaks for itself.
What I'll do is I'll take that one under advisement, and we'll deal with that on Wednesday at 3:30 when we talk about jury instructions.
Okay. The last thing I want to cover, I don't think it'll take more than 20 minutes or so to get this done, is the battery and the false imprisonment and the related punitive parts of this. That's count 2 and I believe count 5, if I'm not mistaken. And
so are you dealing with them together?
They're very similar arguments, so I'm going to try to fit them in together because they're both claims that result in punitive damages.
So I'm clear, you're moving for directed verdict on the false imprisonment claim, you're moving for directed verdict on the battery claim, and then you're moving for directed verdict with respect to punitive damages.
The related punitive damages. and I'm probably not moving for directed verdict on each and every part of this, so I need to break this down for you. In count 2 alleging false imprisonment, it's 3 claims. One for that week of October 7th to October 13th, one for the EEG room on the 18th and 20th of October, and the third for the 2 hours or so on January 6th. And as to each of those, the analysis of the tort and the punitive damage is a little bit different. On the claim between October 7th and 13th, forgetting, there's probably a day in there that I do have immunity for, but I'm not going to worry about that for directed verdict. There is evidence that the family wants to take the child out. This child has been sent there by Dr. Hannah to go to an emergency room. The child is in either an emergency room or a pediatric intensive care unit. There is nobody that's got on the stand as an expert and said that that child didn't belong in an emergency room or an ICU unit during that time period. So for a false imprisonment, the question is whether or not we restrained, the jury instruction on this is whether we, without legal authority, intentionally caused Maya Kowalski to be restrained against her will in a manner that was unreasonable and unwarranted under the circumstances. Now, without legal authority might be a problem in this case for at least a chunk of this time. But
you're talking about the 24-hour issue.
Yes, yeah. But the facts are that they brought a child in that had serious enough medical situation, whatever it was, that she needed to be in an intensive care unit at that time, period of time. Mama is not wanting to take this child out to transfer the child to another hospital. There's no arrangements to do that. Admittedly, Dr. Hannah has on his schedule some appointment with the child a day or two later. There's no evidence that he was going to provide more ketamine to that child then or ever in this point in time. So the evidence here is that they want the hospital to roll Maya out in her wheelchair up to the curb, put her in their car to take her home. For a mother who is a nurse infusionist who has IV grade ketamine in her home.
Well, I mean, the reality is, though, that there is evidence that Jack Kowalski said he wanted to take him out and was threatened with arrest. So doesn't that kind of defeat your argument? I mean, I understand the jury might agree that the balance of the evidence is that there's no false imprisonment.
The biggest thing, I figured that you would deny that on the claim for intent. But when you get to the punitive damages claim, those doctors who said, no, we're not letting you out, and even if they said, we're going to ask that you be arrested, that the standard on this is that the employee engaged in intentional misconduct. Well, the alternative is gross negligence, but what we have here is an intentional tort, and no one's ever alleged negligence, let alone gross negligence, about this event. But when you look at the definitions, intentional misconduct for punitive is the defendant had actual knowledge of the wrongfulness of the conduct and the high probability that injury or damage to the claimant would result, and despite that knowledge, intentionally pursued that course of conduct, resulting in injury or damage. I'm sorry, but my doctors, in deciding to keep her in the intensive care unit, didn't violate the intentional misconduct standard. This shouldn't be going to the jury against them on punitive damages, and that means even if there were proof that there was some management level thing done by the hospital, it shouldn't go to against the hospital either. That this one fails on punitive damages. Now, as to the second one in the EEG room, she has said that she's trapped there, and the full 48-hour tape isn't there, and we haven't discussed it. So I think there's a prima facie case at this point in time that it goes to the jury as to whether or not she was trapped there as well. But the question of whether or not, again, it meets the intentional misconduct of the gross negligence standards, This child had been moved from one room to another room to another room. And by the way, I'm not sure it's accurate, but she's testified there was a surveillance camera in every single one of those rooms. We just moved her into another room with another surveillance camera that was in fact on, and she didn't know it. And so,
Well, I think she testified she was specifically told it wasn't working or wasn't on or something.
Right. And admittedly, the toilet situation was different and all of that. But from the is there a high probability that injury or damage to the claimant would result from that? And I don't think there's enough to go to punitive damages on the EEG room. As to the restraint for 2 hours on January 6th, there is evidence that I think is sufficient to go to the jury on the primary count there. The evidence is that the people doing this were told by people above them, but the highest person in this chain is a quote-unquote risk manager in the risk management department. Risk management is a term used because the statutes use that term. There's no evidence. Was this Patty Condon? I forget. Patty Condon, what her job description is, what level she is. That they have to have her be at a sufficient management level that she basically speaks for the corporation, and they haven't shown that she's anything other than the lowest person in the risk management department. So I don't think that they have proven by clear and convincing evidence, which is what they have to do, that they have a claim that even if there was something that rose to the level of punitive at the individual employee level, translates to a claim against the hospital because management made a decision that fit within the statute. So I don't believe this one goes to the jury on punitive damages as well. I can run through the battery ones as well if you want to. There's 3 battery ones about the same kind of arguments. So
sure.
On battery, there are claims against Catherine Beatty or about Catherine Beatty that kind of break into 2 categories. One is that she hugged and patted, slapped, or otherwise gave unwanted affection to Maya Kowalski in the chapel and I think maybe in some other places. The other is that she committed battery in conjunction with that photographing session on January 6th. I think there's 2 different things going on there. With, again, for the testimony that she gave, the hugs and the like, as a technical tort, intent for battery is fairly limited. If you do this conduct and with that the other party would expect to be offensive. And I believe that this is enough to go to the jury on that. But again, when you go to the punitive damages section, this conduct, she didn't hit the child, she didn't slap the child, there's no bruises, there's not the normal things that one thinks about when one talks about a battery on a human being. And for this to be something that fits into the definition where she was doing something that rose to the level of intentional misconduct, or even though unpled, gross negligence by hugging this child in the chapel and having her on her lap, I don't, under those definitions, this is not enough for punitive damages against her. And equally important, since only the hospital is left in this, there's no knowledge that anybody other than the 2 of them were involved in this. There's no knowledge that anybody saw these things at that time. So, and there are theories that this was, ratified. The risk management department admitted they knew nothing about any of these things. They couldn't, at the corporate level, ratify this because they didn't even know about these things. So I don't think this goes to punitive damages against the hospital. As to the January 6th incident, I'm not contesting that there's prima facie evidence that can go to the jury on whether or not that's a battery in that situation. As to her, she was told to do it. It's not like it was an idea from her. And again, the proof as to where it was that the decision was made and whether that was, it certainly wasn't an officer, director, or the board for this hospital. And the people that they've had, they really haven't, they didn't call them to the stand. They haven't done anything to explain at what level they are in the hospital that would make them have the authority under the case law that it takes to be a manager in this situation. They had a duty to prove that by clear and convincing evidence, so I think we're entitled to a directed verdict on that.
Let me make sure I understand what you're actually moving for
Yep.
directed verdict. With respect to battery, you are not moving for directed verdict on the hugs and kisses or the photo session. You are simply moving for directed verdict as to a claim for punitive damages for those two.
That's correct.
Complaints. With respect to the false imprisonment, you're not moving for punitive damages with respect to any of the three instances, but you are moving for directed verdict with respect to the punitive
Well,
damages.
I did move for for directed on the first one.
On the October 7th?
I think you denied that.
Well, I think you said that you thought that I was going to deny it. I don't
That's
think
true.
I have technically denied it yet.
I didn't say I didn't move for it. I think you denied that one. The other two, I was conceding on.
Okay, so to be clear, I will go ahead now officially deny the directed verdict with respect to the October 7th through October 13th motion, since there was none made on the non-punitive damage component for the balance. All we really need to talk about is the punitive damage.
I got one more. I'm sorry.
On count 2 or 5?
It's one more battery.
Okay.
At some place towards, I think it may have been the 8th, towards the end of this, they added language to this that said that when I was asking them to specify more precisely where things were, that unnamed social workers or nurses committed battery by things they did, grabbing, pushing, maneuvering, or otherwise touching Maya Kowalski while transporting her to the EG room or in that room. So in that 2-day period, they're alleging that there was a battery. Now, they were unnamed social workers and nurses. I listened to the testimony of Maya, which is really the only testimony from their side about these events. She complained about a lot of things, but she didn't complain about being battered in some fashion by someone transporting her there. She did in the pediatric care unit, which isn't alleged in this count, which maybe goes to some other count, because that would have been a couple weeks earlier at least. But she hasn't identified anyone or described anything that she thought was a battery. And even inside the room, she didn't testify to something that she thought was offensive conduct by them that should be a battery. So as to that one, I don't think they have proved, not proved, but presented prima facie case, a battery on some unnamed, I mean, I don't even know who to call as an unnamed social worker or nurse who supposedly did this, because she hadn't described any of this in her testimony. And then once again, since she didn't describe it to any extent, I don't think it fits within the definitions of intentional misconduct or gross negligence by those people as to this. Maybe they're upset about her being in that room, but as to the batteries, I'm not hearing evidence by that. And I'm also not hearing evidence of the next layer up, that one of these, that the management was involved in this, knew about it, or that a mid-level manager or a sufficiently high manager has done anything. So I don't think that this one should go to the jury, both for either compensatory or punitive damages.
Well, let me hear first on this battery with respect to the transport to the EEG room and while we're in the EEG room. Anyone want to, from the plaintiff side, want to give me some testimony that was actually adduced at trial as to that variant of battery?
The battery in the EEG room, although they failed to identify who those therapists, nurses, social workers were, you have the video evidence. You have a situation in which Maya Kowalski is transferred and she's left whimpering and crying in her wheelchair on video, and there's audio of this. So that transfer in the EEG room should suffice. Regarding transfer.
What's the harmful or offensive contact, I should say?
It's the manner in which they're forcing this little girl without pain medication to attempt to support herself and transfer to the wheelchair. And she's picked up and manhandled and put in that wheelchair, and at the end of it, she's left whimpering and crying. That's offensive to Maya Kowalski, and she testified for the pain.
Do you want to hear a legal argument? I'm a little more on that. I'm ready to talk about the punitive damages.
Yeah, let's talk about punitive damages.
Okay.
Well, let me short circuit part of it. I'm going to deny that portion of the punitive damage claim with respect to the EEG room and the January 6th photo session for the false imprisonment claim, and I will deny the punitive damage motion with respect to the photo session. I think you need to talk about the October 7th through October 13th punitive damage component. I have denied the motion with respect to the underlying conduct, but I have not addressed the punitive damages, and then address the punitive damages with respect to the hugs and kisses portion of the battery claim.
Okay. Yeah, I think the starting point should be, you heard some talk about, well, this person wasn't a managing agent or this person wasn't whatever level. That's a red herring. You already ruled you're going to give the standard punitive damage instruction on corporate liability.
Right, and for EEG and the photo session, both false imprisonment and battery, I agree.
Okay.
It's just, Mr. Altenberg had a really unique argument relative to that first week, and no involvement of risk management during that.
Well, Your Honor, you have a situation where there is no DCF hold when she first comes in there, and they keep her there. They tell the parents, you're going to get arrested if you take her out of there.
Well, and the false imprisonment claim is going to go to the jury. I agree. It's just whether there's clear and convincing evidence of the statutory requirement for punitive damages for that allegation of false imprisonment.
And let me try to assist here. Maybe it won't be of any assistance. The arguments I heard from Mr. Altenberg was that under the intentional misconduct standard in 76872, we have to show actual knowledge of the wrongfulness of that October 7th, 13th sequestering, holding her there. In the medical record itself, we can demonstrate actual knowledge that they didn't have legal authority. That's at Exhibit 1001, page 63, in which they document at the time that they're threatening this family and holding Maya Kowalski there is no DCF hold in the record. That is the actual knowledge of the hospital that you can then find that there's intentional misconduct.
Well, you need to have somebody high enough on the food chain.
So, high enough on the food chain. We also have in evidence, and I can't cite the exhibit number at the moment, all of the committee rosters of the various physicians that were involved here. And as we said before, the who's who of this hospital. We have the testimony of Dr. Laura Vos, for example, who was involved in that first week, and that's the only time she was involved, who was the chair of the ethics committee. That should be high enough in the food chain as a director, officer, executive committee member of that hospital to suffice for 76872. There's a host of them. Dr. Young, I believe, was the chair of pediatrics. You have Dr. Bahar Posey. You have Dr. Elliott. Each of these physicians, Dr. Dolan, each of these that I'm naming have committee appointments within that hospital. And I can get the exhibit number.
I think it might be Exhibit 2142. That's.
And we have, thank you, and we have, at the beginning of this, we have the testimony of Deborah Hansen, the social worker at the time, who testified that these were directives coming down for risk management, even in those early days. So we have direct testimony on this issue. And again, the second DCA has found that the risk management involvement was enough to suffice for managerial involvement.
Well, let's be clear, and I think it's fair to the second DCA. they were treating this as a writ of certiorari, and I think they denied it as opposed to dismissed, but I don't think that's,
They denied it, they didn't find it was a jurisdictional issue, they denied it.
so it was denied,
But
okay.
you're right, it's a cert standard.
Talk about the hugs and the kisses as far as punitive damages
For battery.
for battery.
Well,
Because, I mean, that one, I'm less confident I've heard anything that risk management had anything to do with telling Ms. Beatty to or not to use physical affection, i.e. hugs and kisses, you know,
Well, it
patting
wasn't-
the leg or anything like that.
it's not just physical affection. I mean, she slapped her too. We heard that, right? To test for pain. I'm looking at DIN.
I can talk to.
Okay.
Speak to that for a moment. So as the court is aware, there's 3 different avenues for punitive damages under 768-723. And the third is that the employer, hospital, engaged in conduct that constituted gross negligence and that contributed to the loss, damages, or injuries suffered by the claimant. And in the record, you have here Ms. Beatty having disciplinary problems at the time. So you have a corrective action notice, you have a social worker who has a proclivity towards physical contact, physical aggression, and there is no retraining or follow-on or monitoring of this social worker. There's notice from the family and the family's attorney on multiple occasions that they're aware that Ms. Beatty is doing these things, and then there's no follow-up action to those notices that maybe Ms. Beatty should be removed here. So it was grossly negligent to leave a woman like Ms. Beatty in charge of Maya Kowalski and to allow this to happen. And they will notice by mid-November that she had a tendency towards this type of aggression or action towards Maya Kowalski.
And Your Honor, if we can also look at Part B of the standard instructions, because if they have notice of it, then they're condoning it or ratifying it.
Anything else, Mr. Altenberg?
I'm going to go back, by the way, to more or less preserve the issue that I started with on punitive damages, which is you gave them the option to plead the statute, and they chose to plead willful, wrongful, and malicious. And if I were still under the theory that was in the pleadings when this trial started, I would be entitled to a directed verdict on all of this. But there's no allegations any place in this about gross negligence for any of these things. So I don't see how they get to those standards. And even still, bringing back up the negligent hiring or supervision or retention of Ms. Beatty, which is no longer in the case, as part of this, what it was that they claimed the hospital should have done vis-a-vis when these hugs took place. I don't know that we know from the record what date this event such happened was. Do we? I don't. But one way or the other, I don't see that this is enough to have clear and convincing evidence that this goes to the jury on punitive damages.
Mr. Carl, just to let you know, we're not going to do evidence after this.
I figured that out all on my own, Judge.
Okay, this is what we're doing with respect to count 2 false imprisonment. For the week of October 7th through the 13th, there was a DV motion made as to false imprisonment. I'm denying that. As it relates to the punitive damage component for that week, I will take that under advisement. Still under false imprisonment for the EEG, there was no motion for directed verdict as to the false imprisonment count, but there was with respect to the punitive damages for the EEG time period, and I am denying the defendant's motion for directed verdict as to punitive damages. That will go to the jury. With respect to the photo session on January 6, 2017, there was no motion for directed verdict as to the false imprisonment count. There was a directed verdict motion with respect to the punitive damages count. I will deny the defendant's motion for directed verdict as to that. That punitive damage claim will go to the jury. With respect to battery, the Hugs and Kisses battery claim was not made. The punitive damage motion the court will take under advisement. The photo session battery was not, there was no DV motion made, but the defendant did move for directed verdict as to the punitive damages with respect to the photo session, and I am denying the motion for directed verdict for punies, and that will go, punitives will go to the jury on the photo session battery claim. On the transport to the EEG room and the EEG, I will take that under advisement, and therefore I'll also take the punitive damage component under advisement. But I will think about that. Do you have any other motions? Now, this is what I would like to do, Madam Court Reporter. And I know I'm asking a tremendous amount from you. If I can get this transcript from 3 o'clock to now by, mid-afternoon tomorrow, 3 o'clock-ish, 4 o'clock-ish, I'll take it home with me, and my goal, I don't want to make it a promise, but my goal would be that for some or all of the ones that I've taken under advisement, at the beginning of our discussions on jury instructions, I can say, it's in, it's out, I'm still thinking about it, and be able to, at the beginning of our jury instruction discussion, have narrowed my under advisement list down. But that presupposes I get the transcript.
And to refresh my recollection, we're doing that conference, I believe, by Zoom, and Mr. Elliott and I can coordinate from Tampa. I'm not sure whether, did we finally decide when we were starting that?
3:30.
3:30.
3:30, and hopefully we can, because I think you said that you've got a good number of the instructions finalized, and there's not, and I know some of it's dependent on these rules. I get that.
Right. But I believe between now and then we can make a lot of progress on this and narrow things. As long as Mr. Elliott has authority from his co-counsel that he and I can fix these things up to a large extent and narrow down what it is in the fight.
And then to that extent, if wherever and whatever you have on the jury instructions, again, by that 3 or 4 o'clock, if you can send to Ms. Sybak so that I can take that with me tomorrow night. Tomorrow's Tuesday.
Tuesday. So you want to be able to have those looked at over Tuesday night? Okay.
Correct.
Gotcha. We can do our best to do that, yes.
And if it's not finished, that's fine, but wherever you're at, so that I'm just not coming into it cold.
We have a good document, and I think the two of us can probably get a lot of comments.
Judge, what we've been doing is exchanging, and we're making notes about what we think should be changed in the others, or what we think should be added for ours. And what we may do, acceptable to the court, is maybe submit you one thing that has everything in it with our commentary, and then you can pick from that.
We've been using the same color coding that you've seen from me before. This time I've got somebody who's working on the same color coding.
And that's fine. It's just there's a color printer here, and so I can print it out and take it with me. Okay. Are there anything else we have to do tonight, or are we able to call today?
Just for the record, Judge, and I know the response, but the plaintiffs moved for a directed verdict on all defenses and on all counts that remain.
What?
Well, don't you have to? What's it? The plaintiff is moving for directed verdict, even though the defense hasn't rested its case.
There's some case law out there that if you fail to move for a directed verdict at the close of, well, I guess that's more for the defense, but for the affirmative defenses, There's some case law out there, or there was, maybe it's not there anymore, that if you fail to move for a directed verdict at the close of the plaintiff's case, then you may be barred from re-raising it at the end of the case. So I'm just trying to cover that.
For the record, I will not maintain an argument that he has failed to preserve a motion for directed verdict by not making one at this point in time.
Anything else? We are in recess until 8:30 tomorrow.
Thank you, Your Honor.